communicated to the advocate on record of the plaintiff by a letter dated 6th of February 2025. In spite of receipt of the communication, the plaintiff has not cured the defects. Accordingly, the matter is placed before this court. Today also, when the matter is called, none appears on behalf of the plaintiff, no accommodation is sought. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 24th of February 2025. It is made clear that on the date fixed, if none appears on behalf of the plaintiff, appropriate order will be passed. Next.
This is my application. On the last occasion, your lordship had directed
I appear for the
the
contempt.
contemptors to file an affidavit in the form of an undertaking.
But the affidavits have been filed.
They filed the affidavit. My lordship will kindly take up any one of these affidavits. There's only one aspect which I must indicate.
Yes.
Lordship has that paragraph 4. The contemptor, all the affidavits are parameteria, my lord. Apart from granting leave, this honorable court even directed that an undertaking should be furnished by me, indicating I will not use. I hereby state that I shall not use IHM in any manner whatsoever. I hereby state in my firm, institute such and such, of which I am a partner, shall not use the mark. That apart, I also state I shall not use a domain name. I undertake that I shall comply with the order. Now, my lord, if your lordship sees the verification of this paragraph, it's not verified. It's only a submission. Paragraph 5.
Where is
Look.
paragraph 5?
Oh, I'm sorry.
Where is the
No. Paragraph 5 you have not affirmed.
It's just a submission. Then there's no undertaking as
But
such.
if lordship sees, my lord, I think, my lord,
1 and 2.
it should have been mentioned. Paragraph 5 are matters of my should be a
Can't be
submission.
matters of record.
No.
That's
But
his
that was
undertaking to
the
court.
inadvertent error. Paragraph 5 should have been mentioned after paragraph 4, 7, and 8.
Yes.
Because I have to affirm paragraph 5.
In between 4 and 7. Where is the 6?
And in fact, my lord, since I have not mentioned paragraph 5 and it is mentioned the rest are my humble submission, I have to affirm paragraph 5 as a submission.
That's correct. Tomorrow something will happen because
But undertaking
Because my
is not a
lordship
submission.
No, my lord, kindly see, my lord, I cannot affirm it as true to knowledge. It cannot be a matter of record. It has to be my submission.
It has to be affirmed as his undertaking given to court.
Yes, the pleading is that I am undertaking. That is the reason why I have specifically used that word.
Knowledge, those paragraphs are matter of records and humble submission. Yes, Mr. Ghosh.
My lord, rest are his submissions.
Submission, yes.
My lord, a submission is something which the court may accept, which the court may not accept.
I am accepting.
But my lord, the undertaking.
I will record your
lordship.
I will record your sum.
Lordship, that is all. If your lordship records it as an undertaking, that is sufficient.
Yes, I will record that. So there is nothing remain?
No.
No.
Then it can be disposed of.
Sense appearing for the plaintiff, petitioner. Sense appearing for the alleged contemners. And in terms of the order passed by this court, the alleged contemners have filed their supplementary affidavit. In the supplementary affidavit, the alleged contemners have stated as follows. Paragraph 5. So not paragraph 5, huh? Police. Counsel for the petitioner submits that in the affidavit portion, the plaintiff, the alleged contemners have not stated whether the paragraph 5 has not affirmed, and the counsel for the plaintiff submit that the alleged contemner has not affirmed with regard to the contention made in paragraph 5 of the supplementary affidavit. Okay? Full stop. Counsel for the alleged contemner submit that the statement made in paragraph 5 is the submissions of the alleged contemners, which is already recorded in paragraph 10 of the said affidavit. And he submitted that may be treated as the submission of the alleged contemners.
Maybe treated as the undertaking.
And let's full stop. Consider the submission made by the counsel for the respective parties. This court by an order dated
January 17.
Order dated 17 January 2025 directed the alleged contenders to file an affidavit stating that they will not use IIHM and comply with the interim order passed by this court. Accordingly, the alleged contenders have filed the said affidavit, is making the said statement in paragraph 5 above. Accordingly, this court has treated the said statement made in paragraph 5 as undertaking of the alleged contenders. Full stop. In view of the above, the undertaking given the supplementary affidavit filed by the alleged contender by making the above mentioned undertaking, this court has accepted the same. According full stop, this court find that nothing remains in the present application. Accordingly, CC 53 of 2022 is disposed of.
Great, great,
A rule, if any issue, is discharged.
great.
Number 5. What application?
Lordship, I appear for contempt number 5, 6, 7, and 8. Contempt number 8 has taken out an application for modification of your Lordship's order dated
I would like to use an
6th of
affidavit.
January 2025. Lordship would kindly take that order, Lordship. It's at page 30. May I file my affidavit of service, Lordship? क्या बोले थे मुझे? जानी ना हमारे
Yes. What application you filed?
Lordship, I have filed an application for modification of your Lordship's order dated 6th of January 2025.
What is the application for? Where is the application?
Lordship,
G1?
GA1 of 2025. Lordship, the order is at page 30. Relevant portion, Lordship, starts from page 31 at the bottom.
Counsel for the Present District Collector. Which portion?
Lordship, page 31 at the bottom. Lordship, the last two lines, sir. Lordship, may I read? Considering the submission made by counsel for the plaintiff, the District Collector Tirupati and District Collector Tiruvalur are directed to direct the concerned authorities, Tehsildar or Sub-Registrar or any competent authority not to register any kind of deeds or things with respect of the aforesaid landed property in respect of description which has been forwarded by the District Collectors before this court and to submit the report on the next date fixed. So, Lordship, by this order, directed the collector of Tirupati and Tiruvalur. Lordship, they have filed their affidavit. Lordship would kindly take their affidavit, which is at page 197, the relevant portion.
Yes, yes, tell me.
Lordship, yes. Lordship would kindly come to just page 197. Lordship, there are the collector of Tirupati and Tiruvalur both have filed their affidavit, giving the description of the properties owned by contender number 8 and also of Jairam Chaudhary. Lordship, so far description of the property concerned from serial number 17 to 25 is concerned. Lordship would kindly take page 197. This is the affidavit of the collector of Tiruvalur. Lordship, he has given description of the properties. Lordship would take serial number 1 to 16 and then from 17 to 25. So for 17 to 25 is concerned, Lordship, I have no objection with regard to this particular order, as this is the subject matter of this contempt application. Village number 28, against which injunction order were passed. But Lordship, so far the serial number 1 to 16 is concerned, Lordship, they are his native properties. It has got nothing to do with this contempt application. So Lordship, I am only seeking that if save and accept the properties mentioned in serial number 1 to 16 of this affidavit is concerned, be excluded from this order, Lordship.
Okay.
As this is not part of this contempt application, and they're not seeking any orders against my personal asset. If your Lordship would take their contempt application, Lordship would kindly take.
No, they are not. This court has called for the report because the other contemners are not coming. That's why I ask for the all the assets of the parties who are the contemner. Let the place before this court, then we'll see the court.
Lordship, yes, Lordship.
Let remain
But
for the,
Lordship,
what
this
is the
one-
urgency immediately?
Lordship, 1 to 16 it is my native property.
Maybe
If-
let
Lordship-
let the file affidavit. Let the
Very
file
well, Lordship. Lordship, let them. But Lordship
Yes.
would kindly appreciate by this order, your Lordship has restrained the registrar
Correct.
not to do any registry of my personal property,
Correct.
Lordship.
Yes,
My client, Lordship, is a farmer.
maybe.
He's using
He
this
is one of the
property.
contemner.
Lordship.
This court only knows he is one of the contemner. Other contemners not appearing. The court has to execute the order either this way or that way. And the collector has submitted the report in which your property is also there. Your maybe your own property, whatever. Let be decided. Let other contemners come and this will be decided. I am not passing any order for attachment. Only I restrain for alienating the property, madam.
Lordship, but this is my personal property. Lordship would
Maybe-
kindly take their contempt application.
Maybe
once.
on that
Lordship would
day,
kindly
you have made a submission. I have no problem. Whatever. Now all the things has been over. Now you are coming with an application for deletion.
Lordship, when this order
When you are
was
in trouble,
passed,
you are telling that yes, my property, yes, order may pass. This may be done. That may be done. Now all the things has been coming to the closure of the matter. Now you are file an application for deletion of the name, deletion of the property from the list. Let that property be remain in the list. Let other compliance may be done by the superintendent of police with regard to the warrant of arrest of the other persons. Then we'll see to that.
Lordship, if other contemners, Mr. Jairam Chaudhary is absconding, Lordship, I should not be punished. If a Lordship would
I
take
am not
page
punishing
62,
you.
Lordship would take page 62, their prayers in their contempt application, what they are seeking. Lordship would take their contempt application. Lordship, moreover, this affidavit was never served upon me on that day when the order was passed. There is a direction that I would be served with the copy of the affidavit. I didn't get any opportunity to look into these details, Lordship. After this order was passed,
Okay,
and
I
the
will consider, madam. I will consider.
Lordship, his business has collapsed. Lordship would kindly appreciate. I
will
understand Jairam Chaudhary is absconding.
I will consider. I will consider all these things.
Lordship, we are not selling this property.
Okay.
Which is subject
If
matter
you're
of
not
this
selling,
contempt.
so what is the
Lordship,
problem?
the subject matter of this contempt application, I have no issue.
Then
Lordship, my
the court
personal
has,
property.
court has not stated it is to be transferred to the
Lordship
petitioner.
knows in today's Lordship era, everyone is doing business by securing its property, Lordship. It
Okay.
is very difficult to run a business. Lordship, but
So
take page 62 once.
and suffering for the petitioners / plaintiff. Petitioner or petitioners? Plaintiffs. How many?
No, we are appearing for the petitioners in the contempt.
Petitioners or petitioner? One
One
or
petition.
petitioner / plaintiff. So and so appearing for the contemner number.
Lordship, this application is by 5 to 8.
You are appearing for
5 to 8, Lordship.
contemner number 5 to 8. You are appearing for so and so appearing for the district collector Tiruvallur. Full stop. The contender number 8 had filed an application being GA1 of 2025, praying for modification of the order dated 6th of January 2025. Police counsel for the petitioner prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. The learned counsel appearing for the district collector Tiruvallur has filed affidavit. What is this?
This is a status report. Lordship was directed to file.
Status report of the property of
Further step, can you see page number 11? Status report. Page number 50.
has filed the status report.
Manoj, we'll kindly have a look at page 12, paragraph 4. Status report containing details of the land of Mr. D. Solayappan. Paragraph 4, contender number 8.
Has submitted the details of the land of Mr. D. Solayappan. D. Solayappan. Let the same be kept with the record. Full stop. Please the man. Full stop. The Deputy Sheriff of Calcutta has submitted a report dated 11th of February 2025. ये और एक रिपोर्ट था कहाँ and Deputy Collector submitted the report dated 11th of February 2025, wherein it reveals that the office has dispatched the warrant to the respective police authorities and sent the materials, and the same was duly received by the officer in charge, Tiruchannur Police Station, Tirupati, Andhra Pradesh on 20 January 2025, and as well as the office superintendent, office of the superintendent of police, Tirupati, Andhra Pradesh on 20 January 2025. But in spite of receipt of the said warrant, no report has been submitted. Accordingly, the officer in charge, Tiruchannur Police Station, Tirupati, Andhra Pradesh, as well as the Superintendent of Police, Tirupati, Andhra Pradesh, are directed to appear before this court through virtual mode in person to explain as to why no report has been submitted with regard to the warrant issued by the office on on 11th of March 2020.
Two humble submissions. Firstly, let the registrar of this honorable court communicate this order. That's the first thing. Second thing, if your lordship kindly takes a look at the 6th January 2025 order, this fresh warrant has been issued. This is the steps which they have not been able to take.
Yeah.
Would it be lordship's pleasure, just thinking aloud, would it be lordship's pleasure to direct the authorities there to put the alleged contender numbers 1, 2, and 4 in the no-flying list, so that they cannot.
Let us submit the report first. Let us submit the report. What is the report is coming from the superintendent of police?
And from the portion which my learned friend had filed the report, that would possibly be only in the contempt, not in the GA.
Not in the GA. Not in the GA.
Two separate possible.
Let them. At 10:30 AM.
Lordship, just one indulgence. The receiver has filed a report. I am entitled to receive a copy of the report. They are not serving me. I have written them letters. Mr. Anuj Singh was appointed a receiver to take symbolic possession. Lordship, he has filed a report. I have not been given copy of report, Lordship.
That day you are not appeared.
No, Lordship. Initially, it's a change brief, Lordship.
Correct.
Yes.
When the matter, okay, on the next occasion you mention, I will see.
Lordship, I have written them letters to serve me a copy. I should know what is there in the report, Lordship. Grateful.
We shall.
Yeah. Iska. You have filed a notice of motion. What is the notice of motion you filed?
Notice of motion was not accepted by the department. I don't know the reason. So with affidavit of service, I am filing
Once
this.
your GA has been given, GA is the notice of motion or
With notice of motion.
master summon?
It's with notice of motion.
If it is notice of some, how the GA has been registered without the notice of
Lordship, I really do not know, but I was told to file my affidavit of service with notice of motion.
How it can be?
I really do not understand, Lordship. The same thing I inquired from my clerk, that why notice of motion.
Without the notice of motion, how the GA has been listed here?
Lordship, I really do not know. But it was there with the affidavit of service was prepared later on. Filing
Affidavit of
section.
service is okay.
Lordship, filing section, I am told by my clerk, filing section requested my clerk to annex notice of motion with affidavit of service.
Who?
Lordship, the filing section.
the department,
Bapunda.
full stop. The learned counsel appearing for the alleged content number 8 has filed the affidavit of service along with the notice of motion. When the court has inquired why the notice of motion has not been filed in the department, comma, the learned counsel appearing for the alleged content number 8 submitted before this court that the office has directed the learned counsel to file the notice of motion before this court. In view of the above, the department is directed to submit report why the notice of motion has not been accepted by the office when the GA was filed by the petitioner.
Grateful, Lordship.
This is my application. May I file my reply to the opposition filed by the contemners, Your Lordship?
Item number 6.
Your Lordship, this is basically an application where the contemners were injuncted from using the word Solaris with their name Siddhi Vinayak. We are continuing with the same this from last several years. We are the previous users. Your Lordship would kindly come to Your Lordship's order passed on 19 July. The order under contempt, Your Lordship, at page 40.
19 July
2024, Your Lordship, which was corrected by Your Lordship on 24th
Where is the
July.
19 July?
Lordship,
Corrected by an order dated 12th November.
19 July, Your Lordship, page 40 of my application.
40 of your application.
Annexure B, Your Lordship, page 40. At page 46, Your Lordship, paragraph 13.
46. Yes.
In view of the above, the respondents, its main agents and assigns from infringing the petitioner's registered trademark Solaris by rendering service under the mark Solaris, along with any other word or setting up any project under the mark Solaris in conjunction with any other word in respect of the real estate business or any other.
So what has happened now?
They are still continuing to use the trademark with the word Solaris. We have annexed. Your Lordship would kindly take up my reply to their opposition.
Siddhi Vinayak Solaris.
Lordship, we have taken out a printout from the website of their website where they are continuing to use the word Solaris.
Page 30.
Your Lordship.
Yes.
Though they have undertaken not to use it, the only reply they have given is they have issued notice to the website not to use it, but they couldn't control the website.
Okay.
They are still, even today, they are still continuing with their website. In their
Where
website.
is the affidavit? Where is the affidavit in opposition?
Lordship, affidavit in opposition was filed on the last occasion by them.
Who has filed?
All the four contemners.
Arya Sumant.
Separate 4 affidavits have been filed by.
Arya Sumant is the applicant before Your Lordship.
So where is
their
that?
opposition is filed by 4 different persons. One is Priyambad Rana Mahapatro.
Yes. Which paragraph?
Lordship, I'll just.
Which paragraph?
Lordship would kindly come to paragraph 7.
Yes.
Photographs, those are said to be collected are taken from the archive and was collected on 4th November and are the basic documents of the incident. The said documents were inserted long prior to July 19, 2024 and collected from the archive through website. It transpired from the website of the Siddhi Vinayak such and such that the company had stopped all activities relating to any advertisement in the website.
Yes.
The aforesaid documents are not at all posted after the order under contempt. The contemners have never made any arrangement of posting, but they have not taken out this from the website.
Yes. Yes. Shall I call?
My lord?
Shall I call your persons?
No, my lord, let me make my submission.
No, make. I am transferably satisfied from the document.
My lord, kindly
Your submission
take.
it is.
No, my lord, kindly take. If your lordship has already determined to call them, your lordship can. I have got nothing to say.
The publication which has been made, that is wrong. Kindly come to the
My lord,
affidavit and reply, page 30.
Not every, my lord, kindly take the petition first.
I am asking one question to you, sir.
Yes, my lord.
Kindly come to the reply, page 30.
Yes.
It is not your document, tell me.
My lord, where it was collected. Lord, kindly see the last. My lord, here, my lord. 4th November 2024. My lord, it is
But
from,
it's still in the
it is from
website.
archive. No, my lord, kindly take my reply. Opposition, my lord.
Hmm.
Kindly take, my lord, the only annexure which I have annexed. Page, my lord, 14.
Yes.
We are currently updating our website.
Hmm.
It is totally closed.
So that's why
My lord, kindly.
is totally closed. If it is totally closed, why it is appearing?
My lord, this is from archive, my lord. If anyone, my lord, say, my lord.
Archive, you have to remove this.
No, I am not renewing.
You have to remove.
My lord,
You have to
I have already.
remove.
My lord, kindly see, my lord, that has been collected on 4th November.
This
And
is-
my lord, the petition was affirmed on 5th November.
Hmm.
My lord, this is a pre-planned petition. This is a pre-planned petition, my lord. My lord, kindly, if your lordship have the, my lord, the what they did, my lord, many persons, many companies have been used the word Solaris.
Hmm.
Not my client only.
Hmm.
In Tamil Nadu, my lord, in
What is the
Andhra
order?
Pradesh,
What is the date of the order?
19 July.
19 July, which was, my lord, amended on 25th July.
19 July 2024.
And, my lord, 25th July, it was amendment. My lord, there is a mistake in the order.
Hmm.
My lord, we have already closed before, my lord, immediately after appraising the order of your lordship.
Hmm.
This is collected from the archive, from the museum itself. My lord, anyone can go in the website. My lord, he can collect it.
Hmm.
My lord, say for Victoria. My lord, anyone can collect the picture of Victoria on any day, on any time. My lord, this is the basic, my lord. My lord, kindly appreciate section 63 of Evidence Act. It is a, my lord, secondary evidence.
Hmm.
It has to be proved by primary evidence.
Hmm. Okay. I am fixing a date. Let he adduce the evidence and you adduce the evidence.
Yes, your
63, this court will comply. Let your person come and say
My lord, all four.
you are on the 63. Then the court is ready to take the evidence of your client.
My lord, I couldn't understand. 63.
You were telling that 63 is to be proved. Then I will call your client to prove that under section 63 this is not a it is a forged document or it has been.
My lord, I am not saying
Then
forged. My lord,
I am asking one question whether you are removed from the website or not. Only one question I am putting. Whether you have given so many advertisement, it has to be removed. Otherwise, it will remain in the website.
No steps, no document disclosed that they have taken.
You are telling that
steps.
you are not using, but you have already used, but that is to be removed.
My lord, kindly give me some time, my lord. I will call them and ask them. I need to take instruction then.
What instruction? Maybe
Whether-
after the order that is there, only I am asking, show me that it has been removed from the website. It has to be removed. It cannot be continuing the website.
My lord, what I am trying to submit your lordship, my lord. My lord, anyone can go in
That's
the
what I'm
internet.
telling. Anyone can go and
In the internet. and
internet.
can have,
Unless if it is removed, it will not find in the internet. If my name is the internet in the website, if my name is not removed, it will remain in my name will be in the website. If my name has been removed, it will not find my name in the website, sir.
well, then kindly give me some time, my lord. I will inquire into the matter, my lord. I am not an internet expert, my lord. Your lordship
is
You
knows.
have to take the instruction. You are telling me you are teaching this code with regards to 63.
No, I am
how
not
the
teaching.
63 is
My
to
lord,
be proved.
that was my defense, my lord.
What the defense? That's why if
That
your
was my
defense, if
defense,
your
my
defense,
lord.
I am calling your petitioner to prove the under 63, sir.
That is my defense, my lord. I am not here to teach anyone, my lord. Rather, I am a student of law.
So-and-so appearing for the petition, so-and-so appearing for the alleged contemners. Counsel for the petition has filed the affidavit in reply. After serving the copy to the learned counsel for the alleged contemner, let the same be kept with the record. Counsel for the alleged contemners prays for time for taking instruction whether the website has been removed from the whether the advertisement with regard to Solaris is removed from the website or not. How much time?
3 weeks, my lord.
Lord,
They are from not of Calcutta, my lord. They are of Odisha.
Where from?
Odisha, Bhubaneswar.
Odisha is here only 8-hour journey by road.
Now that's true, my lord.
Hmm.
That's true. But if your lordship kindly give, my lord, they are 4. They need to tell.
Within 2 weeks from date.
they are
Let the
committing
matter-
contempt and they are opposing my application before the
Let
other
the
court.
matter
your lordship.
appear on.
Definitely.
Let the matter appear on 4th of March 2025.
Lot of companies are used Solaris. You
next.
have not affected by them. You are only affected by me. Fantastic.
Well, I'm for the petition, my lord. As per the last order, I have already served them. The copy. This is my affidavit of service. As would be evident from the service, my lord, different number, content number 1 and 2, the service has already been affected on 3 contemners, my lord. And but it could not be served on contemner number 3, my lord, as would be evident from the postal record, my lord, at which would be appear at from page 20. The item written insufficient address.
So what do you want?
My lord, rule may be issued, my lord, upon the contemners, my lord. Because they are continuing to.
With regard to the 3, now notice is issued. Notice is not served, no?
With regard to content number 3, that was not served, my
Not
lord,
served.
insufficient address. So for 1 and 2, my lord.
So and so suffering for the plaintiff / petitioner. None appears on the plaintiff application has filed affidavit showing that contempt application along with the documents have been duly served on the alleged 1 and 2, but the notice could not be served upon the contempt number 3 and the alleged contempt number 2. Counsel for the plaintiff / petition submit that in spite of the receipt of the notice, none appears on behalf of the content number 1 and 2. Petitioner has filed the present application on the allegation that the alleged contemners have violated the order passed by this court dated 3rd October.
3rd October.
And dated 3rd October 2025. 2024. By the counsel for the petition, this court find that receipt authority, the alleged contemners have not appeared. Accordingly, it is a fit case wherein the rule can be issued. Issue rule upon the alleged content number 1 and 2. Direction to appear before this court in person on 7th of March 2025. In the meantime, the petitioner is directed to take appropriate steps on the alleged content number 3. The petitioner is directed to take appropriate steps for issuance of rule.
Ideally, if your lordship sees that notary is very fair,
No,
then
to
it
start off,
for affidavit.
to start off, I said ready because just to intimidate him.
Well, ready
That I am asking.
the application or not, I don't know. But to say that it is an ideal case for an affidavit to be filed. And now I leave it to Mr. Chaudhary.
No, right. Actually, I didn't want to move it, which is why he was doing all this.
Doesn't give any effect, further effect to the further debit note.
No, I'll tell you, Lordship. I did obtain an order before the City Civil Court. That, my lord, was
unfortunate commercial.
That was, but on my lord, on merits, under my learned friend's argument on specific relief act, I was able to repel.
No, but other than that, I can submit on merits also.
Sorry.
I will show from the other plaint which I have already filed the correspondence between the parties. And how false affidavit that broker has given, the defendant number 2. He has exchanged mail with the broker. I have exchanged mail with the broker. It is a common case that these contracts are entered into through the broker.
No, but truly speaking,
let
on
us
merits,
come back on a good, your lordship will decide whether any injunction can be passed. So I'll file a very short affidavit. Your lordship will, 7 days time, I can file an affidavit.
So appearing for the. Consider the paragraph 22 and 23 of the
judgment.
Sen. Mr. Sen has to consider this too.
Paragraph
22, page 165, paragraph 22, 23 of the order of Justice Bhattacharya. Suffering from the petitioner, plaintiff, suffering for the defendant.
Yes, but I have marked it. In my copy, it is marked.
Yes.
Counsel for the defendant, press for time to file affidavit.
No, but this I'll tell you, Lordship, my lord, this is not on merits.
Okay,
This
that's why
yes,
I have
this my submission
I have
was.
gone through this order.
Well, merits, my lord, I believe I do have an excellent case.
No, I
but,
say that prima facie case is not there.
but to be very candid, now that he's filed a suit in Gurugram, my lord, then, my lord, I want to examine whether, my lord, whether I at all this order is necessary or not.
Yes.
Once already filed.
Yes, now that it's already filed,
And
He will disclose that.
And my lord, and
I
this will be an exact issue in the suit.
Which-
Gurugram suit.
That was the first or this one?
Gurugram suit is the first suit.
no, now it is.
Now it is.
Now it is.
Uh,
Now it is.
File affidavit. Let affidavit be filed within a week. Within a week. Reply within a week thereafter. Within a week thereafter. List the matter on 7th March.
Obliged.
My lord, I will advise my client to withdraw the suit with leave to file this as a counter
Counterclaim
claim.
in
No, that is better.
I was that
is-
would have been an ideal case.
That is
that
the
is-
ideal case.
That is the
that is what I will
Otherwise,
withdraw him.
Otherwise, again, section 10 and this and
Yes,
that.
there's
yes,
no
yes.
point because I'll tell your lordship very
And
candidly.
section 10 is bound to come. That
Section 10 is bound to come. And my lord, interlocutory relief I can get, but even if I get the injunction, suit already filed. Number 2, section 10, if it comes, it makes no sense. My lord, keeping this pending here. And number 3, this can at best go as a defense over there. Actually, I don't even need a counter claim.
Take the court fee written and file.
I wanted to do that, but my advocate on record is in hospital, so I couldn't consult him.
Okay, come on.
That is the reason. Otherwise, I'm grateful.
Let's see this one. Now this is our application for. My lord, I am for the defendant number 1. Amendment of the plaintiff, my lord. The only amendment.
Item number 10.
Yes, my lord. The only amendment we are seeking, my lord, is the change of name of the defendant.
Amendment.
Yes, my lord. From private limited to public limited, my lord. My lord, I just want to show only one thing, my lord. Kindly takes up page 8. The page 8 of their application, my lord. The name was changed, my lord, in 2022. I just want to know what
When the suit was filed. 24.
suit was filed on 24. What prevented them to, I mean, file it with the name? Well, this suit was renumbered as.
Now, what is the what is the name of the company?
Well, now the name is Jivanram Shodhatra Industries Limited, my lord.
Shodhatra Industries. Earlier it was
Jivanram Shodhatra Industries Private Limited.
only private has been removed.
Yes, ma'am.
Now it is the limited company.
Yes, my lord. And the suit is of actually 2021. This has been renumbered.
Old one.
Yes, ma'am.
Old suit.
Yes, but what prevented them to come up with such an
Well,
amendment? There was earlier application pending for which has been filed by them for extension of time to file the written statement. That was heard in 2024, and thereafter we have taken out this application to amend it. As your lordship thinks.
I filed the written statement.
Yes.
So suffering for the plaintiff, so suffering for the defendant. The plaintiff has filed the present application being GA Com 5 of 2025, praying for amendment in the cost title. In the cost title, other portion? No, only
My
cost
lord, the
title.
only change is in the cost title.
No mentioning of the name, other
that is
portion.
At page 9 and page 8.
Amendment in the cost title, amendment in the cost title with regard to the name of the plaintiff. Police counsel for the plaintiff submitted at the time of filing of the suit. The company was
That is the name.
the plaintiff company was the private limited company. Now, in the year 2022, it has been changed as limited company. Accordingly, the plaintiff intend to delete the word private in the cost name of the cost title of the plaintiff company. Full stop. At the learned counsel for the full stop. Counsel for the defendant raised objection and submitted that the order of amendment has been passed by the registrar of company. Order of amendment of the name of the company is passed by the registrar of company in the year 2022, but the plaintiff has filed the present application after 3 years, and as such the same is liable to be dismissed. Heard the learned counsel for the respective parties. This court find that the plaintiff has initially filed the suit in the year 2021. Subsequently, it was renumbered as CS number 324 of 2025 and 324 of 2024. No, 20. What is the number of the suit?
The old number, my lord.
CS Com 5 of 2025. 2025. Considering the submission made by the counsel for the respective parties, this court find that the amendment as sought by the plaintiff is formal in nature only with regard to the name of the plaintiff company, and the same will not change the nature and character of the suit, and none of the parties will be prejudiced. Accordingly, prayer A and B of the master summary is allowed. GA5 will dismiss. The plaintiff is directed. Give the name. And the plaintiff is directed to. After the amendment is carried out, the amended copy of the plaintiff is supplied to the learned counsel for the defendants.
Item 11, Lordship, I appear for the respondent. I'm extremely embarrassed to pray for only 1 week's further accommodation to file my opposition. Lordship, I will indicate that this loan account has actually migrated. Lordship remembers that this was a dispute pre-classification of NPA, and all the records of the pre-classification is with the branch from which it has now migrated. It is almost ready, Lordship, of only a week's accommodation. We'll be able to file it by
affidavit.
If not by next day, before that.
I will not stand in the way. Kindly makes it peremptory. And the ad interim order that was passed by your lordship on 16th of December and extended on 10th of January, that is there till 21st of February. Lordship will kindly extend that.
How much time?
Lordship, a week's time. Next Monday, Lordship, I shall.
So and so appearing for the plaintiff, so and so appearing for the defendant. Police counsel for the defendant prays for extension of time to file affidavit in opposition. Full stop. For the ends of justice and as a matter of last chance, time to file affidavit in opposition in connection with GA Com 1 of 2024 is extended for a further period of 1 week from date. Reply, if any, there to be filed within
1 week.
1 week thereafter. Full stop. List the matter on 17th March 2025. Full stop. Counsel for the plaintiff submit that the interim order granted that is going to be expired on 21st of February 2025. Accordingly, the interim order, which is going to be expired on 21st of February 2025, is extended till 21st of March 2025 or until further order, whichever is.
I'm extremely obliged, Lordship. Extremely.
Yes. Excellent. Counsel.
It's 11:30. Item number 1 of the non-commercial list.
Your Lordship, I'm led by Miss Shomali Mukhopadhyay in this matter. Lordship, I have been informed that the witness could not be present here today because he's not well.
It is.
Well, we had for the plaintiff lordship recalls, we had finished our chief. They for the defendant, they were to lead their witness.
Acha, your witness.
We have finished.
Your Lordship, I'm requesting to keep the matter any day after 10 days. Your Lordship, the witness is not well.
How many witnesses you are having?
The defense is of adverse possession, so it should be not. There should not be many.
Lordship, maybe two.
But problem is that within 10 days it is not possible for this court to give the date. So and so appearing for the plaintiff, so and so appearing for the defendant. The matter is fixed today for witness action of the defendant, but the counsel for the defendant prays for adjournment. Considering the submission made by the counsel for the defendant, the case is adjourned. Let them give the any date.
Let it be made peremptory, my lord, because
no, April. 4th April. 4th April at 3 p.m. It is made clear that on the date fixed, if the defendant failed to bring the evidence, no adjournment shall be granted. Great Lord. Yes.
Item number 12.
क्या के लिए और orders अपेयर नहीं then appears on behalf of either of the parties. No accommodation is sought for. The matter was listed on 6th of December. The matter was listed on 6th of December 2024. On the said date, the learned counsel for the plaintiff submit that the talk of settlement between the defendant is going on, and accordingly prays for time. On the submission made by the counsel for the plaintiff, the case was adjourned till 28th of January 2025. On 28th January 2025, again the learned counsel for the plaintiff prays for time, and according case was adjourned till today, till 11th of February 2020. Today, when the matter is called, none appears on behalf of either of the parties, no accommodation is sought for. Let the matter go out. Let the matter be listed in the warning list.
Application item number 30.
Your Lordship, I appear for the respondent. It's for acceptance of my WS. It is within 120 days, Your Lordship.
This application for acceptance of WS.
Your Lordship.
When you receive the writ of summons?
Writ of summons was received on?
Was served upon the defendant on 9th October.
9th October.
Sole defendant. Only one defendant.
I am for the plaintiff, Lordship, but I could not have received the copy of the
Yes, after accept what?
written statement.
You have received the copy, na?
No, Lordship.
Your Lordship.
This application?
The written statement is attached to the application, Your Lordship.
Yes, it is attached.
It's Annexure B.
So when you affirm the written statement?
5th of February, Your Lordship.
5th of February. Before 120 days?
Before 120 days, Your Lordship. 120 days was expiring on 6th of February. We took Your Lordship's leave on 5th of February and we have filed it on, affirmed it and filed it on 5th of February itself.
5th of February. And that is the 120th day is 6th of February.
6th of February, Your Lordship.
How 6th of February? October 24. October 24. 9th October. 20 days. Okay. Yes. Have you calculated?
Lordship, yes.
Yes.
Lordship, I short for accommodation for 1 week actually.
For what?
My next senior engage in another.
It's okay. Only the acceptance of referees within 120 days I am allowing with the cost.
Yes, I have.
Your
It's within
Lordship,
120
it's
days.
But within 120 days, Your Lordship.
So appearing for the plaintiff, so appearing for the defendant. Full stop. The defendant has filed the present application being GA Com 4 of 2025, praying for extension of time for filing written statement. Counsel for the plaintiff submit that the defendant has received the writ of summons on 9th of October 2024 and has entered appearance in the suit on 5th of November 2024. Full stop. Counsel for the defendant submit that the counsel for the advocate on record of the defendant has directed the defendant to bring all the documents so as to enable the learned counsel to prepare the written statement. Bring the necessary documents for preparing of written statement. Accordingly, full stop. According, the documents were placed and the draft written statement has been prepared. In the meantime, the period of 30 days was over. After preparation of the draft return statement, the same was finalized by the learned senior advocate, due to which the defendant could not file the return statement within the period of 30 days. But full stop. Learned counsel for the plaintiff and defendant submit that the defendant has affirmed the return statement on 5th of February 2025 and filed before this court on the same day with the leave of this court. Counsel for the defendant submitted. The defendant has filed the return statement, and though has not filed the return statement within 30 days, that though the defendant has not filed the return statement within a period of 30 days, but have filed the return statement within the outer period of 120 days and paid for acceptance of the return statement. Per contra, learned counsel for the plaintiff has raised objection and submitted that no cause has been shown as to why the defendant has not filed the return statement within the period of 30 days. Full stop. Counsel for the plaintiff further submitted the cause shown by the defendant is not counsel for the plaintiff submitted there is no cause shown for acceptance of the written statement after the period of 30 days and paid for rejection of the application. At the learned counsel for the respective parties, this court find that the written statement, the copy of the writ of summons was served upon the defendant on 9th of October 2024, and the defendant has filed the written statement, has affirmed the written statement and filed in the department on 5th of February 2025, that is within the period of 120 days. The copy of the written statement is also enclosed with the instant application. On the 5th of February 2025, the defendant has filed the written statement in the department with the leave of this court, subject to acceptance by this court. Considering the above, this court find that the defendant has shown sufficient cause for non-filing of the written statement within a period of 30 days, but has filed the written statement within the outer period of 120 days. Accordingly, this court find that one opportunity should be given to the defendant to file written statement subject to payment of cost of rupees 5,000 to the State Legal Service Authority within a week from date. The department is directed to accept the written statement subject to scrutiny by the department. The defendant is directed to serve the copy of the written statement to the counsel for the plaintiff in course of the day. There is no counterclaim?
No counterclaim, Your Lordship.
List and GA number so disposed of. Let the matter appear on 25th of February 2025. The plaintiff is directed to produce, not 25th, 4th of March 2025. The defendant is directed to produce the receipt showing that the cost has been paid in the State Legal Service.
My lord, in item 14 and 15, I am for the defendant.
Yes.
My
Your
application.
Lordship, I am for the plaintiff. They filed two applications, one for rejection of plaint and one for revocation of clause 12 leave. Lordship, may I pay only one indulgence, Your Lordship. Our Lordship affidavit in opposition, Your Lordship, is ready but could not be finalized. If Your Lordship kindly give some time so that Your Lordship, the affidavits can be completed, Your Lordship.
File two applications, 3 and 4.
3 and
what
4.
are the applications?
One is rejection of plaint and another is revocation of clause 12 leave. Yes, Your Lordship.
Two separate.
It should be combined, but anyhow, Your Lordship.
I filed two separate applications, my lord. I'll explain when the applications are taken up.
Only some time, Your Lordship, may be granted, Your Lordship.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff prays for extension of time to file affidavit in opposition in connection with GA3 and GA4 of 2025. Let affidavit in opposition be filed within 2 weeks.
2 weeks.
Reply, if any, there to be filed within 2 weeks.
2 weeks, my lord.
After release the matter on 25th of March 2025.
My lord, one more submission. My lord, the matter is also listed on 25th of February for framing of issues. Now, my lord, my learned friend allowed me an inspection only last week, and I'm doing it today. So there, I'll need some time to file my admission denial.
That I will see. Let you complete in the meantime.
Very well.
Can it be on 26th, Your Lordship?
26th, then 28th March.
28th.
28th March.
Very well. Right.
Number 16.
I'm appearing for the petitioner, Your Lordship.
My lord, this is my application. This, my lord, essentially in the nature of an application under Order 22, Rule 10. My lord, the plaintiff number 3, my lord, has died. Now, all the plaintiffs, my lord, were trustees of this trust, my lord, who owns the suit property. Now, since the trust could not have sued, my lord, all the trustees were added as plaintiffs. Now, plaintiff number 3 has died on, my lord, 25th of April, 2024, my lord. The death certificate is at page 17. There has since been a reconstitution of the trust, my lord, on 27th of November 2024. My lord, the deed is at page number 18, my lord. So in terms of the reconstitution, my lord, one Mr. Padmanabh Jalan is now the newly inducted member, the trustee, my lord, in place and state of the plaintiff number 3, my lord. If he could be, my lord, added as a plaintiff, my lord, in place of the plaintiff number 3. And consequential, my lord, amendment in the address, registered address, my lord, it actually remains the same. It only has to be reaffirmed.
Name. Only
My-
name.
Only the name.
Instead of the Sudarshan Kumar Jalan, it
Padmanabh Jalan.
Mr. Padmanabh Jalan. And this is an undefended suit, my lord. So this.
so appearing for the plaintiff. None appears on behalf of the defendant. Plaintiff has filed the present application being GA Com 5 of 2025, praying for amendment in the plaint by recording the death of the plaintiff number 3 and substitute the new trustee, namely
Mr. Padmanabh Jalan.
Siri Padmanabh Jalan. Page 12. Padmanabh Jalan. Counsel for the plaintiff submitted. The plaintiff number 3 died on 25th of April 2024, and after the death of the plaintiff number 3, who is one of the trustee of the trust, a deed of trust has been reconstituted, and one Mr. Padmanabh Jalan has been made as one of the trustee in place of plaintiff number 3. Consider the submission made by the counsel for the plaintiff. This court finds that the amendment as sought for by the plaintiff is formal in nature, and the death of the plaintiff number 3 is required to be brought on record, and the substitution of the plaintiff is to be bring on record. In view of the submission, in view of the above, prayer A and B, A, B, and C of the master is allowed. GA 5 of Com 2025 disposed.
I'm grateful, my lord.
Next.
My lord. GA6, my lord. It is appearing at my.
What is GA6?
GA6
is for the plaintiff.
No, my lord. I am for the defendant number 4.
My lord.
Defendant number 4.
I am for defendant number 1 to 3, led by Mr. Pratip Mukherjee. He is appearing for another court, and I am appearing for short passover.
Who is for the plaintiff?
My lord, GA6 is at my instance. It's an application for expunging my name under Order 1, Rule 10 from the array of defendants. My lord. I'm the
defendant number 3.
I'm the defendant number 4, my lord.
Defendant number 4. You wanted to be deleted?
Yes, my lord. Yes.
From the cause title?
Yes, my lord. From the plaintiff. I don't want to be, because I...
Yes, you are for the 1 and 2 and 3.
1 and 2.
Yes, plaintiff, what is your submission? Deletion?
I don't know what is grounds for.
Have you not served the copy?
No, it has. It has been served, my lord.
Will
But I
you file
believe,
the
my lord, the
affidavit?
suit papers are also appearing, my lord. Because I have unfortunately not annexed the plaint. So on the last occasion, your lordship directed that the suit papers would also be. Application, I'm not carrying. My lord, may I just place my case, my lord?
No affidavit. You will not file affidavit.
No, on the last occasion, they said that they will not file an affidavit, my lord. If they want to file an affidavit, my lord, I will not. But it's a very short point, perhaps, my lord. So one look at the plaint, perhaps, my lord, will. be convinced as to why I've taken out this application.
Yes.
Yes, defendant number. So, my lord, I am no one in the company.
Defendant number 6.
Defendant number 4, my lord. Yes, my lord. I am no one in the company, my lord.
Hmm.
This is a suit for goods delivered, and this is basically a money suit, my lord. So, my lord, the defendant number 1, that is Royal Built Infrastructure Private Limited, that is the principal defendant, and defendant number 2 and 3, that is Pintu Patro and Toroni Patro. If your lordship would take the plaint, my lord. Toroni Patro and Pintu Patro, they are the present directors of the company. And Sanjukta Das, that is me, I am no one in the company. My lord, just kindly takes my GS6 application. It's a very 2-page, 3-page application. I'll just indicate from the present MCA document, which I've annexed in that I am no one in the company, and that only defendant number 1 and 2, 2 and 3 other directors. Your lordship would see page number
Pintu
9.
Patra Taranani.
Yes, page number 9, my lord.
Tarani and Pintu.
Pintu, they are the defendant number 2 and 3. Now, my lord, if your lordship takes the plaint again, my lord. So basically, the defendants, they had sold some marbles and granites to the plaintiff. The work order, my lord, is appearing at page number 20. This is of the plaint. Of the plaint. Lord, your lordship will see this is to Raija the Marbles. Raija the Marbles is the plaintiff. And this is a work order dated November 3, 2015, my lord.
Correct.
There are the details of the goods, my lord. For example, polished green stones, granites. Now, my lord, if your lordship takes page number 21, your lordship would see the director S. Day at the bottom of the page, my lord.
Yes. Director.
Yes, there's the director. Now, S. Day was the then director of the defendant company.
Yes.
Now, my lord, annexure B onwards, my lord, these are all challans. Your lordship would see these challans have been issued by Raija the Marbles, my lord, in my name, that is Royal Built. And my lord, the challans, they all go in the company's name, my lord. So even the directors are not even appearing in these challans as it would, my lord. Now, my lord, your lordship takes annexure C. This is a ledger at their behest, my lord. This is at page number 75. Yes, my lord. Page number 75, annexure C of the plaint, my lord.
Yes.
Now, my lord, this quantifies their claim, my lord, as to how many goods and so no name, at least not my name, is appearing in this document itself. My endeavor today before my lord is to show that from their annexures that I am nowhere appearing. Now, annexure D, my lord, the annexure D is the most important document, my lord. The next page, page number 76 onwards. Lordship would see this is a letter from Royal Built, that is the defendant company, to Raija the Marbles, the plaintiff, 27/11/2018. May I kindly place this, my lord?
Yes, it was signed by the Pintu.
Yes, my lord. Now, also, my lord, kindly see this, the fourth paragraph in the fourth line in the second paragraph, my lord. After starting Royal Built Infrastructure, lordship has it. Company got a huge loss of few. Meanwhile, other 2 directors left the position. So, my lord, this is being written in October. This has been written in November 2018. Other 2 directors. This includes S. Day and another director. Not even me. Now, my lord, this is again signed by Pintu Pat. Now, my lord, subsequent letters, my lord, written by Raija the Marbles to Royal Built. That is at page number 77. These are all the communications which has led up to this dispute, my lord. All documents addressed to either Pintu Patro, who is the principal.
That's correct, sir. The communication is to be made through in the name of the company.
Yes,
correct.
Yes,
but where in the plaint,
yes,
what is your description has been given?
My description has been given, my lord. Yes. Now, they have taken pleadings against me, my lord.
Correct. That's why that is the main.
I'll indicate those as well, my lord. I'll indicate those as well. Your lordship would take paragraph number 3, page 3, my lord, of the plaint. The defendant number 2 to 4 approached and introduced themselves as the owner, ultimate beneficiaries of the defendant number 1, being the family company, completely controlled, managed, and owned by the family members, including the defendant number 2, 3, and 4 as the directors thereof. This line, my lord, defendant number 2, 3, and 4 as the directors thereof.
Correct.
This is a false statement, my lord. This would have been correct to the extent of 2 and 3. 4, I am no one, man. Now, my lord, paragraph number 5, my lord. The defendant number 2 to 4 being the directors of the defendant number 1. They are well reputed. Again, my lord, it's a false statement. I'm not a director. Now, my lord, your lordship would take paragraph number 9, my lord. Relying on such representations to be true and genuine, the negotiations ensured between the parties being the plaintiff and the defendants, and it was finally agreed and understood that A, the plaintiff would supply marbles, granite, and agreed and upon demand being made by the defendant. The plural and singular aspect of this very important, my lord. They have categorically used defendant when it is royal built, that is a defendant, and they have taken my name to use the S in the defendants. So this is upon demand being made by the defendant. B, the plaintiff would raise invoices upon the defendant for the supply affected by
Sir,
them as
this
per
is
the
the
orders paid.
company. This is the company.
Company, my
right?
lord.
The
So, my lord, in order to
plaintiff, as per the case of the plaintiff, they are claiming that you are one of the director. That's why you have been made as a party to this. So you show the document. You have been out from the.
I've never
directorship.
been in the company, my lord.
So file.
I've never been in the
File your
company.
written statement.
No, my lord, that is a difficulty, my lord.
What
120 days over. I've missed that opportunity, my lord. I had to come through this
there are
application.
contentions here, and you have been made as a director. You
Yes.
show me. You are
Yes,
telling that you have never been. So the document, which page number, the annexer A of your affidavit, the application.
Yes.
This is showing this with regard to the 2024.
Yes,
We don't know from
Well, all the
2015.
communications, the paragraphs appertinent there to the annexures, not a single annexure or even the letters, they contain my name, my lord.
Not necessary. See,
Not necessary.
You
So only
company, if any correspondence is made to all directors or to the company.
To the company, my lord.
Then
my only
the
endeavor.
challan will be sent to the director or to the company.
The challans, my lord, when the work was being done, my lord, when there was no dispute, it was with the company.
Then,
But when dispute started, then, my lord, I'll have to indicate those letters as well, my lord, where these people are communicating. Pintu Patra particularly is communicating with the plaintiff. And in those communications, my lord, I do not come up. I'll just indicate those paragraphs, those documents as well, my lord. My lord, your lordship will kindly take annexure G, page number 112 of the plaint.
Yes.
Well, this is the defendant's letter in reply to their demand. The very first paragraph, that Royal Built Infrastructure Private Limited is a partnership firm, and Mr. Pintu Patra and Mrs. Toroni Patra are the new partners. Ms. Sanjukta Das was never a partner, nor was engaged with Royal Built Infrastructure at any point of time. This is the statement of the defendant number 2 and 3. That is the only relevant point, my lord. If a lordship has to take it to evidence, well, this is plenty document. This is plenty evidence enough to exclude my.
Yes. Next.
Even their demand letter, my lord, which is appearing at page number 107. More particularly 108, my lord. This is their demand letter, my lord. The lordship will see that number 4 is me. This is in the earlier document that I indicated, my lord. This is in reply to this document.
Where is your reply to this letter?
That the document that I just indicated, my lord. I have not replied, my lord.
You're not.
I have not replied, my lord.
Have you received this?
My lord, 70A Motilal Gupta Road. I don't even reside there, my lord.
Correct. Have you received this?
My lord, I have not, my lord. How can I? Because I don't stay there, my lord.
Where is the environment in this
Yes, my lord.
application?
Your lordship will take my GA6 application.
Yeah, that's why I'm asking.
Yes.
Where is that?
Where is the title, my lord?
Where is the averment that the no notice they have relied upon 108 that has not been served to you?
Regarding that, my lord, I have not taken a pleading, my lord.
Then?
Yes. Regarding. But I have taken a pleading, my lord, in paragraph number 2, my lord. It is stated that the defendant number 4 applicant was never a director or shareholder of the defendant 1 company and has no business relation with the defendant 1 company, my lord. The applicant has no privity of contract with the defendant. My lord, even if I am not on the aspect of defendants, my lord, if I divulge from that, my lord, there is no privity of contract with me, my lord. At least from the documents that they have relied upon in the plaint, my lord.
Yes.
I can be very well taken to evidence, my lord.
Okay, anything further?
Only one thing, my lord, the test for Order 1, Rule 10 is not whether there are any pleadings against me, my lord. The test is whether a decree can be, effective decree can be passed in my absence or presence, my lord. That is the question, my lord.
If it is found that you are the partner, you are the director, then
my lord, my case is that
liability will go to whom?
My lord, that is the case, my lord.
Yes, Mr.
May I just rely on one judgment?
Page 1 and 2. The other defendants are taking the shoulder. He is not the partner or the director. And he come this 112. It is your document.
Very short, very short. Second lap of dilatory tactics when the first lap is already exhausted.
Maybe.
I'm coming, madam. I'm coming. Madam, only after that they have appeared for the first time. Madam, in the plaint, as a plaintiff, madam, whom I will array, whom I will not, in my cost title, that will depend on myself. Madam, that I cannot bring everyone under the sun. Whoever choosing my fancy.
That show me.
Yes, madam, kindly come to my averments from paragraph 3 to 7. Madam.
That he has shown.
And thereafter,
that he has shown. But first thing, with regard to the legal notice which you have sent, kindly come to the paragraph 107 and 108. Legal notice 9th August 2021 and 9th August 2020, page 108.
108.
Yes,
Got it? And kindly come to the page 112. Paragraph 1, second line. So-and-so was never the partner nor was engaged with the Royal so-and-so. So if they are taking the responsibility, the company.
Yes, madam.
So what purpose would be keeping?
This is their averment, madam.
Yes.
But that should be tested at the time of trial.
Why? Once the other company is telling that he was not my partner, he was not engaged. So why how the court will test it? And you admitted this document.
But kindly see, madam. May he not be a partner, madam, but he has his representation. He made a pivot. He had a pivotal role, my lord.
Show me.
Representation.
Show.
Kindly come from the averment of the plaint, my lord. Defendant number 2 to 4, paragraph 3, my lord. Defendant number 2 to 4 approached and introduced themselves as the owner and ultimate beneficiary of the defendant number 1, being the family company completely controlled and managed and owned by their family members.
But the company is telling that he is not the partner or the so-and-so. So how you will prove the paragraph 3?
My lord, defendant number 4, my lord, had clear representation on the basis.
Show me. Show me, is there any correspondence? Is there any letter? Is there anything? Once the company is giving the reply to you that the defendant number 4 is no way connected. Show me. And the company is taking the responsibility from the 18th August letter. You want the decree. Decree against whom?
But the defendant number, may I?
So if you've got the decree, the defendant cannot say no. The defendant number 4 has been deleted. He is entitled for that.
Falling from your lordship, madam. If your lordship kindly allow me to come back tomorrow or day after, madam, on this point, I will definitely substantiate. And this point has fallen from your lordship.
Hopefully, with no additional documents, my lord.
Why should I?
So-and-so suffering for the plaintiff, so-and-so suffering for the defendants, and defendant number 1, 2, 3, and so-and-so suffering for the defendant number 4. Full stop. The defendant number 4 has filed the present application being GA Com 6 of 2025, praying for deletion of his name from the suit. Counsel for the defendant number 4 has argued at length. Full stop. Counsel for the plaintiff prays for time. Accordingly, case is adjourned. Let the matter appear on 21st February under the same heading. बनी जाए. Okay. Yes.
Not the application is appearing at my instance. I appear on behalf of the defendant numbers 1 to 4 in this case. However, this application has only been taken out by the defendant number 4.
Mr. Gunjan Shah is on behalf of the plaintiff. He's on
On legs.
he's on legs in another court, and I'm praying for.
Who has filed this application?
Not I have filed.
What
I
is
have
the
paid.
application for?
The application is for expunging my name from the array of parties. That is similarly placed situation. However, my lord, I have documents to show that I was never a part of the partnership firm.
I'm praying for the short
My lord,
pass
this
over.
happened on 3 different occasions. Kindly allow me to place my case. Then my senior
You will file affidavit.
affidavits are complete.
Where is the affidavit?
Opposition reply both complete.
Affidavit hai?
My lord, may I file my affidavit in reply served on the 24th of January on my.
Okay, come tomorrow, not today. It's senior.
Third occasion.
If I pass over, you will not.
I very extremely.
Okay, I am passing to. Come tomorrow.
Extremely.
Not today.
Lords, this is my IA. I appear for the defendant number 4.
For
It
what?
is for the acceptance of the written statement, my lords.
Who is for the
Lord, I am
plaintiff?
for the plaintiff. Lord.
When the writ of summons was served?
5th October 2024, my lords.
5th October
2024.
24 writ of summons was served.
Yes, my
When
lords.
the written statement is affirmed.
Filed on 31st,
31st
subject
of?
to leave 31st Jan.
Subject to leave of
Of the court, my lords.
Lord, affirmation is possibly not there. My lord,
My
it's
lords, a
prepared.
draft. A draft is annexed.
It is not filed in the department.
It is filed, my lords.
So without the draft, how it can be filed?
My lords, the writ of mass summons has been issued on 31st, my lords. Sorry, yes, my lords, and the affidavit of service has also been filed. My lord, the service has been done on 4th. The writ of summons and the IA, my lords.
Writ of summons, I am not telling.
Yes, my
Have you filed the written statement?
Yes, my lords, it has been filed on 31st. Yes,
It is
my lords.
affirmed?
Yes,
When
my
it
lords.
was affirmed?
It was affirmed on 30th, my lords. There were 2 leaves which were taken from my lords on 30.
Affirmation and fighting.
Yes, my lords.
It has been done.
It has been done, my lords.
Okay, report training. Let the come
Lord,
tomorrow.
this is something I'm not aware of because the written statement does not show any date.
Come
Lord,
tomorrow.
my learned
I
friends
am
are
calling
saying
the
that-
written statement.
Yes.
Come tomorrow. So and so appearing for the plaintiff, so and so appearing for the defendant. The defendant has filed the present application being GA-1 of 2025, praying for acceptance, praying for extension of time to file written statement. Counsel for the plaintiff submitted and defendant submitted. The writ of summons was served upon the defendant on 5th of October 20. Defendant number?
4.
Defendant number 4, huh? Defendant number 4 on 5th of October 2024. And with the leave of this court, the defendant has affirmed the written statement on 5th of January?
31st.
31st of January 2025. Full stop. Though the plaintiff has, and though the defendant has enclosed the copy of the written statement, but this court could not find when the affidavit is affirmed. According, the department is directed to place the written statement filed by the defendant on 31st of December 2025. Please the matter tomorrow. Next.
Grateful.
Lord, I appear for the respondent. I'm being led by Mr. Rai.
For the respondent, Malad.
What happened to the appeal?
Malad,
appeal was released.
Malad, the appeal has been moved, Malad, but Malad, the appeal was moved, but Malad, it was released on personal grounds, Malad. Of one of the honorable judges, Malad. So Malad will kindly give us some more time to get it assigned and to be moved, Malad. Malad keeps it on the 28th, if your lordship, because that's the last date for extension. Your lordship has extended the interim till the 28th. If your lordship keeps that, then we will have some kind of view as to what is happening to the appeal, Malad. We have sent it for assignment. But at this moment, Malad,
sometime Malad in either Malad 26th or 27th, so that we
I
had
am
one
fixing
more
on
day.
25th.
Very well.
Very well.
I am fixing on 25th.
Great. Yes, Malad. Great.
The meantime, Malad, if they want Malad without prejudice to the Malad points taken in the appeal, they can file their affidavit in opposition. Malad,
They will
so
not
that,
take the risk.
so that Malad, we can Malad complete the process of Malad.
So and so appearing for the plaintiff. Plaintiff petitioner. So and so appearing for the respondent. As per the prayer made by the counsel for the respondent, the case adjourned. Let the matter appear on 25th of February 2020.
Grateful.
Grateful, Malad.
20 and connected, I think.
Lordship, I was praying for not this week, Lordship.
Why?
Mr. Thakkar is not there. He was arguing, Lordship. So let it be come up on next Monday, Lordship.
But this is the matter which I had
He has to
mentioned in the
oppose.
morning.
He has to oppose.
Because I am suffering an injunction.
Lordship,
So if
am
I
not
don't
on the
oppose, who
way,
will
Lordship. We have never prayed
Morning
for.
as mentioned, Mr. Bose is telling that he is suffering from
Lordship,
injunction.
I'm
my
not
Your
on the
Lordship,
way of there,
because-
Lordship, only
And appellate
because of
court
the
order is there.
council is not there, Lordship. Lordship.
It's a blanket order of injunction, Your Lordship, against me as well.
I would not have
There
prayed
is a complete bar.
taken a time a single day in this matter, Lordship. So only I was beseeching our
But Your
Lordship,
Lordship,
let it come on the Monday.
I
let it
had
fix
gone
it
in
on Monday.
on up in appeal. Appeal court gave a direction pursuant to which, my lord, 6 and 7 was being heard only. So for the rest of the defendants, they can continue to suffer because they are not in appeal. They did not appeal. That is for them. So far as 6 and 7 is concerned, my lord, in
Lordship
fact, my
will
lord,
fix it on Monday. There's no issue.
Mr. Thakkar has also I was under the impression he's concluded. But my learned friend says
No, he was continuing, Lordship. Judgments were supposed to be shown, Lordship. That is what. Lordship will fix it on the Monday. There is no
so.
issue
Let
on
me
that.
conclude. Then he can
What is then what remains in
in
that
reply he
case?
can
Again in reply he will
rejoin whatever points he has in reply.
May I request your Lordship to kindly take up the matter tomorrow in that case, subject to Mr. Thakkar's availability and this.
That is what just now I had a talk with
When he will back?
next Monday, no, coming Monday, Lordship.
week
Actually, Lordship,
Monday.
on Wednesday he's coming. If your Lordship keeps it, he's saying that let it come on where Monday, Lordship will keep it on Monday. We are not on the way.
Come on 21st. He's coming on Wednesday, na? 19th.
Lordship.
He's coming on.
But he'll be not there on Friday. That is why he said that to be taken up on Friday, because he'll be leaving on Thursday again, Lordship. That is why he has requested me to keep it on Monday, Lordship. Anytime, Lordship will.
The problem. Yeah,
I know, Lordship. He was here only, Lordship. In the last week, entire week he was there, Lordship.
You know,
I know.
the matter is fixed.
Only, Lordship. It was not fixed, so I could
If you know that the matter is fixed, then
any Lordship, any time on Monday, Lordship.
Then may I pay for
May I request?
saying Monday, Mr. Thakkar, some difficulty. You know, my lord, I know your Lordship's diary is extremely possibly the next available time is sometime in the month of April or maybe after the summer vacation. But if your Lordship could accommodate sometime on Monday, if that is otherwise possible.
May I make one humble suggestion, Your Lordship,
Officers,
subject to everybody's
God
convenience?
says it all.
that's why he made this.
That's why.
Otherwise, it is
May
very
I make one submission, Your Lordship, subject to everybody's convenience? Can the defendants conclude their submissions? Thereafter, Mr. Thakkar can
You
make
are not the
submissions in
defendant who
extenso.
can submit right now. Mr. Banerjee.
Please,
don't
Mr.
me.
Bose, please,
And
Mr.
you
Bose, I'm
defendant.
also one of the defendants suffering the orders. Kindly keep your submissions confined to your
As regards the
party.
submission of the dependent, this court has already taken all the things on record on the last talk earlier.
And your Lordship is hearing only the defendant number 6 and 7.
I don't understand the emphasis of Mr. Bose to curtail the rights of other defendants.
Please
Let
read
him
the
make
appeal court's
submissions
order.
for his parties. I will make my submissions when my turn comes, Mr. Bose.
So suffering for the plaintiff. So suffering for the defendant number 6 and 7.
11 and 12, Your Lordship.
So suffering for the 11 and 12 through virtual mode. So suffering for the defendant number 10. Yes, Mr.
No, my lord, I am with Mr. Bose.
He's with
the counsel for the plaintiff prays for time. In view of the above, for the interest of justice, the case is adjourned. Let the matter appear on 25th February at 11:30.
25th February.
Deeply obliged.
I'm very deeply obliged, Your Lordship.
Item number 22. So this is my application, my lord. The Lordship had, my lord, heard, my lord, Mr. Thakkar on, my lord, on the last occasion. My lord, this is a matter where, my lord, copyright, my lord, infringement was, my lord.
This is relating to, my lord, infringement of copyright in respect of
Two books, my lord, were
Acha,
there,
that
my
one,
lord. Yes, my lord. The only difficulty is that Mr. Thakkar is not there, my lord, in court today.
My lord,
That's
can you
what I have
fix
been
up any
instructed.
date because it was heard, my lord,
I can continue, but my lord, I believe Mr. Thakkar would like to give his concluding submission so far as my lord, only my lord, perhaps my lord, 4 or 5 judgments are left, and perhaps we would like to conclude.
Lord, maximum half an hour time may be taken.
So appearing for the plaintiff, so appearing for the defendant, counsel for the defendant, na? Mr. Thakkar is appearing for defendant.
Mr. Thakkar is for defendant.
Yes, my lord.
Defendant.
Defendant.
Counsel for the defendants, press for time.
That may it be on 7th of March, my lord, subject to.
But I believe my lord, Mr. Thakkar is there online. He would be my lord. Mr. Thakkar, K. Thakkar aছেন তো।
Let the matter appear. Let the matter
এটা ওনাকে
appear.
unmute করে দিন।
7th March. 7th March.
Would it be your lordship's pleasure to my lord fix any my lord time?
Then it go. 7th.
On Friday.
Yes, next.
Grateful.
Yes.
Your Lordship, Mr. Shurja Prasad Chattopadhyay is appearing for the plaintiff respondent in this matter, Your Lordship.
I appear for the petitioner.
He's suffering from some personal difficulty, Your Lordship. Kindly, Mr. Shurja Prasad Chattopadhyay, he had already begun his arguments, and he is to conclude his arguments and also place some judgments, Your Lordship. Kindly adjourn it anytime after 2 weeks, Your Lordship.
Written statement.
No, not written statement, my lord. Here, my lord, we had, to a degree, my lord is right. My lord, we had sought recalling of my lord's order, whereby my lord had recorded since the written, the amended plaint was handed over in court to my advocate on record, my lord. That's why, my lord, the time for filing started at that point, my lord. Since we were out of time, we had filed this application.
So appearing for the plaintiff, so appearing for the defendant. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 11th March.
Oblige.
7th March থেকে অন্য কোনো দিন হতে পারে কি আগের ম্যাটারটা?
Yes, next.
I'm sorry, my lord, to interrupt your lordship, my lord, I just got a message. Perhaps he was hearing, my lord, Mr. Thakkar. My lord, he's inside another courtroom, he said. My lord, instead of 7th of March, can it be my lord, any other day? My lord, he's not available on 7th of March also, my lord.
Then 11th March. First one, huh?
11th.
Allowed me kindly fix up a time, Miller, so that it can be finished.
Time, then I will go to the April.
No, my lord. Then 11th of March. My lord. I'm grateful. I'm grateful.
Next.
Lordship, I appear on.
I appear for the defendant number 2, my lord. I was in reply.
Lordship, I'm led by Mr. Shaha. He's traveling today to Delhi, Your Lordship. Lordship.
All are going out of Calcutta. What the Calcutta judge will do?
Lordship, I'm just praying to fix.
Let's not work to the Calcutta judges.
I'm praying for not today, Lordship. Kindly keep it tomorrow at any time, Lordship.
Not today.
Lordship, fixes any time, Lordship, for tomorrow.
Yes, next.
Let's say matter, my lord. 24 and 25 with connected matters.
Next.
Lord, I was making my submission, my lord. So Das Gupta is also here. Okay. My lord, here, my lord, kindly, my lord, recalls this matter, my lord. Where is this? I am for the. My lord, an issue was raised, an application was taken out, my lord. My lord, here, my lord, an agreement was entered, my lord. May I say from starting, my lord, to refresh my lord's memory, my lord. My lord, there was a mortgage deed where, my lord, money as well as, my lord, we had paid a money of around, my lord,
Order 7 ruling. Acha, name.
Yes, my lord, the name was the difference was there, and my lord, they had taken out the point with regard to name. My lord, for that, my lord, we had cited, my lord, judgments, my lord, to show, my lord, that this issue, my lord, they cannot raise, my lord, because they have taken the money. And my lord, therefore, the issue which they are raising is a fraud upon me, my lord, because they have accepted money from me, they have acted upon the deed, they have signed, and also the deed also shows, my lord, that my name, which is the name which is given, my lord, is there, my lord. Now, my lord, they are also taken the point of limitation, my lord, which is, my lord, that will be addressing, my lord. My lord, kindly, my lord, takes their application, my lord, the GA 4th, GA 4, my lord. A 4th, let's see, 4 for GA 4, my lord. GA 4, my lord. Paragraph 6, my lord, they say, my lord, that it is beyond limitation. Now, my lord, may I, my lord, show, my lord, how it is not barred by limitation?
Yes.
My lord, kindly, my lord, be citing a judgment. First, my lord, of my lord. Date look at Bolivia. No, my lord, kindly, my lord, huh? দেখাবো reply দেখাতে হবে তুমি যে পয়েন্টটা নিয়ে দেখাতে হবে my lord I have to show my lord because my lord, they have taken the point of limitation
judgment in reply to
I have to show my lord because they have stated
a chance to
obviously my lord, obviously I'm not no, my lord, the deed of mortgage was on 17/3/2016 my lord. So my lord, the due date of payment my lord, paragraph 14 my lord should be my lord in according to my paragraph 14 of the plain my lord. Can you take the plaint once?
Plaint you annexed?
Yes, my lord, they have annexed, my lord.
Of GF4?
GF4, they have plaint have annexed, but my lord, some documents were missing. So, my lord, my lord, I'll be relying upon the plaint, my lord, I'll show, my lord, paragraph page 12 onwards, my lord. Page 21, paragraph 14, page 21.
Yes.
The further in terms of the agreement, the said loan amount along with interest was supposed to be repaid by the plaintiff by the defendant number 1 by March 16, 2018. That was they were supposed to not pay, my lord. My lord, March 16, 2018, my lord, my limitation for filing the suit, my lord, goes till March 15, 2021. If according to my plaint, my lord.
Yes.
Now, my lord, in between, my lord, there was COVID, my lord, from my lord 15th of March 2020 till 2022, 2022. 20th February 2022, my lord. The suit was instituted on 19/7/2022, my lord. Now, my lord, can you, my lord, take the...
So you got only 1 day?
No, my lord. Can you, my lord, cease, my lord? No, my lord. Now, my lord, can you, my lord, rely upon my 2024 SCC order in Calcutta 10457?
My judgment?
My lord's judgment, my lord. Now, my lord, this is a similar issue, my lord. 2024 SCC online Calcutta 10457. Now, my lord relies upon the Honorable Supreme Court's judgment, and my lord has, my lord, done the calculation, my lord. Well, paragraph 27 is the date, my lord. Paragraph 27 is the calculation done. Now, my lord, the Honorable Supreme Court has excluded from
15 March.
15 March 2020.
28 March 2022.
Now, my lord, I would have filed the suit within 2021, 15th of March 2021. But, my lord, the COVID intervened. So, my lord, the period from 17, the period from the, therefore, my lord, I had excluded, as exhausted rather, the time from 17th March 2018 till 14/3/2020. This period is required to be excluded. And thereafter, when my
March 2020?
My lord, 17th March 2018 till 14/3/2020.
14/3/2020.
So, my lord, I had exhausted 730 days, my lord. Thereafter, my lord, the Honorable Supreme Court excluded, my lord.
So you are having the further 1 year time.
Yes, my lord.
365 days. So that 365 is to be taken into consideration
From the 1st of March 2022.
1st of March 2022.
So there, my lord, I had filed a plaint on 19/7/2022. So my lord, I am within the time, my lord.
So you are having the period of 365 days.
365 days from 1st of March 2022, my lord. It would have, my lord, concluded on 8/28/2023.
You filed the suit on?
My lord, I had filed the suit on, my lord, 19/7 July 2022, my lord. 19 July 2022.
19 July 2022. Within a period. Within 365 days.
Yes, my lord. Also, my lord, in the month of November, 24th November 2021, page 119, my lord, kindly, my lord, takes, my lord, of the application.
Hundred and 19.
19 of the application, my lord.
4. GF4.
No, GF4, my lord. GF4.
Yes.
My lord, kindly, my lord, sees the date of the check.
Issued the check.
Well, they had issued a check 2021. So, my lord, even, my lord, they had acknowledged the jural relationship between the plaintiff and the defendant by issuing a check. But that also, my lord, carried forwards my limitation period for more than, my lord, 3 years from 2021 onwards.
Yes.
Though it has been, the argument might be that it has been issued after the
three period. That
three
is the
period.
argument.
But, my lord, the Supreme Court order has come in, my lord.
Because his argument is that the first period of limitation is over. So you cannot say that this is continuation of the cause of action. So this cannot be taken as a continuous.
But, my lord, my answer is that the Honorable Supreme Court's order is there, along with my lord's order, my lord, is there, my lord, which recognizes the Honorable Supreme Court's order, saying that limitation should be extended for a year's time. And also, my lord, between that, they have issued the check. That also, my lord, under section 25 of the Contract Act, my lord, that also, my lord, extends my relationship, that relationship between the parties, because an instrument has been produced, my lord, which is, my lord, a check, my lord. Now, my lord, with regard to limitation, my lord, now, my lord, kindly, my lord, takes, my lord. There also, my lord, is a mercantile document which they have produced. The check is a mercantile document, my lord. So therefore, my lord, that also, my lord, under 25 of the Indian Contract Act, my lord, my extension, my lord. I'm not going to that argument because, my lord, it is already covered by my lord's judgment and the Supreme Court judgment, my lord. Now, my lord, kindly, my lord, takes, my lord, they have another well, they had taken the regard to commercial suit. This is not a commercial transaction. Well, kindly takes GF4, my lord. Whether at all, my lord, they can take this application, take that point, my lord. Kindly, my lord, takes GF4. My lord, affidavit in support. My lord, they only say that 12A leave has not been taken. They don't say, my lord, this transaction is not a commercial dispute.
Which paragraph?
Paragraph 7, my lord. Other, my lord, paragraph 7, page 9, my lord. It's pertinent to mention that no grounds of urgency has been shown or pleaded, or is this the matter leave sought to be should not be taken. It's a clever tactic to bypass the procedure laid down in the law and deprive the undue advantage. As per the law, the incumbent, the plaintiff to first exhaust the forum of pre-institutional decision prior to this. No, it's established by the plaintiff, my lord. Now, my lord, they themselves, my lord, by saying, my lord, I should have been bound by 12A.
Yes.
they themselves say that it is a commercial dispute, because they don't say it is not a commercial dispute. They never say that. They only say that 12 has not been taken. Otherwise, if they had taken 12-8 or the pre-institution litigation would have been there, they would have agreed to it. They never say that it is not a commercial dispute at all, my lord. My humble submission, my lord, that if a point, my lord, has been urged, my lord, they cannot take the point, my lord. My lord, where do you want to touch it? My lord, এটা কোনটা নিয়ে এটা? এটা কোনটা নিয়ে ছিল? এটা হচ্ছে 25 নিয়ে এটা না? There is a judgment. My lord, there is a judgment of 2021, my lord. কোথায় গেল জাজমেন্টটা? কোথায়? নেই তো। I'm sorry, my lord. No, my lord, I want to, my lord, I don't think you got judgment with regard to, my lord, the law, my lord, that if no pleadings are there, my lord, the applicant cannot raise the issue, my lord, without any pleadings, my lord. Their application, my lord, here, my lord, they are taking the point that the suit is not maintainable, it's not a commercial dispute. Hence, my lord, hence the suit should be barred, my lord. Now, my lord, with regard to the commercial dispute, my lord, they only urge the point that leave under 12A has not been taken.
Correct.
Only, my lord. They don't say in their application that this is not a commercial dispute. Therefore, my lord, as my lord, they do not raise the issue that this is not a commercial dispute, my lord. Now, my lord, with regard to the argument, my lord, they cannot take the point in the argument, my lord. They cannot raise the arguments, my lord. My lord, আর কিছু আছে? My lord, আর কিছু point কি ছিল? And with regard to the name, my lord, I have already, my lord, shown. I've already shown and the judgment of, my lord, the Calcutta High Court, which shows that, my lord, this issue, my lord, they cannot raise, my lord. আর কিছু আছে? My lord, this regarding, my lord, their application of, my lord, GFO. My lord, GA3 is my chapter 39, or judgment upon admission, my lord. GA3, they have to.
GA3 come next day.
Come next day. Commercial.
GA3 they have already argued. I have to show. I have to give my response to his argument.
Mr. Dasgupta always wants to argue first.
But it's their application. They have already argued it. My client wants to re-argue the matter. I have no problem.
Sensation suffering for the plaintiff, sensation suffering for the defendant. Counsel for the plaintiff has already concluded his argument in connection with GA4 of 2023. But due to paucity of time, counsel for the plaintiff could not, and counsel for the defendant could not argue the matter. Accordingly, case adjourned. Let the matter appear tomorrow. Come tomorrow. If time permit, it will be taken. Tomorrow.
Tomorrow, my lord. Actually, tomorrow.
It was the next matter, so I thought,
what is that?
It was a short matter. In fact, Lordship had heard Order 12, Rule 6, only on the point of interest. Lordship wanted me, to make further submissions as to how, that 18% interest.
Come tomorrow, come tomorrow. Or if the time permit, it may be called. I don't know. What with about 2-3 p.m.
Then, we can come back tomorrow. Okay. It won't take more than 5
Not
minutes.
today.
Item number 30.
This is my petition for probate, my lord.
Yes.
PLA 112 of 2023, my lord.
PLA
112 of 2023.
Yes.
My lord, the deceased passed away on 28th March 2009. Death certificate, lordship will find on page 10. Attesting witnesses affidavit is here. All the 3 heirs have given their consent affidavit, my lord. I wish to proceed with the probate, my lord.
Yes.
Will,
Where
my
is the
lord?
bill?
Page 11, my lord.
Page 11. What is the name of the testator or testatrix?
Testator.
Testator.
Sudarshan Kumar Lakhwani.
Sudarshan Kumar Lakhwani. Sudarshan Kumar Lakhwani. Where is the name of the testator? Executor.
Paragraph 2. I hereby appoint Shri Vijay Kumar Lakhmani, son of late Sundarlal Lakhmani, as executor of my last will and testament.
As executor of my last will. Yes, where is the name of the attesting witnesses? What is the date of the will, sir?
Date of the will is, my lord,
2008.
20th March 2008.
Name of attesting witness, where is attesting witness?
Rajesh Lakhwani and Sanjay Lakhwani.
Without any address.
My lord?
Without any address of the witness, attesting witness.
My lord, they've mentioned it in their affidavits.
Affidavit might be. This is not the way. Signing of the attesting witness in the will. Attesting witness should be appropriate names, and we don't know who is the Rajesh Lakhani. How you will give the evidence affidavit? Who is the Rajesh Lakhani? How you can identify?
Rajesh and Sanjay are the two sons, my lord. They have given their
They are the
affidavits.
sons.
Yes, my lord.
They are the sons of the testator.
Two sons and one daughter.
No,
The
this
two sons
Rajesh,
are the attesting witnesses.
Rajesh and Sanjay is
Rajesh
the
and
sons.
Sanjay. Yes, my lord.
When he died?
The 28th March 2009.
19. Where is the legal heirs?
My lord, paragraph 4. Page 3.
Rajesh, Sanjay,
And
Sadhana.
Sadhana.
Who is the petitioner here?
My lord, the executor is
Vijay.
a different relative of them. There's Vijay Lakhmani.
So all are given no objection.
Yes, my lord.
What about the mother?
The mother's passed away in 2019.
Have you disclosed?
Yes, my lord. Page 14 is the death certificate.
Page 14. Death
Shanti
certificate
Devi.
of
2019.
Shanti Devi.
Yes, my lord.
This is Shanti Devi died on
2019.
19. What about the deceased testator?
2009.
Where is that?
Page 10.
2009. 2009 he died, and when you filed an application 2023.
23, my lord. They hadn't filed by that time, my lord.
Why?
Thereafter,
Where is the justification?
my lord,
Explanation.
pleading as such in the will petition, my lord. But after their mother passed away, then they.
Mother passed away subsequently, but he died on 2009. Will is of 2008. Mother died 2012 and 19.
Thereafter, my lord,
why?
they've come up.
Why?
My lord, there's no explanation as such given, but my lord, I'm told that they hadn't taken any steps till the mother, she was
15
suffering.
years, sir.
2009 and 2023 probate, my lord. 14.
14 years. So, some explanation how? Or you have to prove in the solemn form.
My lord, then we shall call the attesting witness if.
How the attesting witness say with regard to the explanation?
My lord,
And all are the family members.
They had given their consent, so we were.
Consent, but there is no explanation for 14 years. There should be some explanation, though there is no exact time, but there should be explanation.
I understand.
Sir. And for 14 years it is.
That's in that case, my lord.
What do you want?
My lord, should we, my lord, the executor, should we bring some for your lordships?
Want to examine the in solemn form?
Yes, my lord.
So applying for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament.
20th March
Dated
2008.
20 March 2008. It is found from the record that the testator died on 28 March 2009, but the petitioner has filed the present application on 28 March 2023. March is a good month, is a good time for the executor, testator, and all these things. And 28 March 2023. So this court find that after 14 years of the death of the testator, the petitioner has filed the present application for grant of probate. In the probate application, the petitioner has not made any explanation as to why the petitioner has filed the present application for grant of probate after the period of 14 years after the death of the testator. So, counsel for the petitioner submit that he will prove the will by on solemn form. Accordingly, case is adjourned. Let the matter appear. Give the date for witness action. Let the matter appear on 7th April 2025 at 3 p.m. for witness access.
3 p.m. my lord. Grateful.
Next.
My lord, item number 31 is my application for grant of probate. My lord, so far as the matter is concerned, after compliance of 283(3), because one of the properties was situated in Mathura, so by dint of the order of this honorable court, the paper publication was carried out, and also in the notice board of the court premises there, and the report of the collectorate from the district of Mathura has come. So the matter was made returnable 10 weeks from the date of the publication, my lord. So all the timeline have lapsed and now it has come. But I'm told that the no caveat certificate is yet to be drawn up, because on the last occasion, your lordship, when had heard the matter, no specific direction was made in the order. Therefore, the department, as I'm told, they have said that because there is no specific direction laid down in the order, we cannot draw up. So I pointed out also the order of 3rd May 2024 of Justice Sinhare, where it was very clearly mentioned, but thereafter they are asking for a specific direction from the honorable court.
So and so appearing for the petitioner. Counsel for the petitioner submitted in terms of the order passed by this court, the petitioner has complied with the provisions of section 283 within bracket 3 of the Indian Succession Act, and the report has also been forwarded by the concerned district judge. The department has not submitted the no caveat certificate. Accordingly, department is directed to submit no caveat certificate and submit report whether any caveat is lodged or not.
Otherwise, all the natural heirs have given their consent.
Lodged or not.
Before
Within a week from date, let the matter appear on 26 February 2020.
Grateful to you. 26 February. Grateful. After you.
My lord, in view of the order, last order, my lord, we have prepared a list of documents, my lord, and already given to the my learned friend, my lord. And my lord, the amendment could not be carried out as the executor is residing in Chhattisgarh, Raipur, my lord. He could not come, my lord, due to his marriage ceremony on his family, my lord. I am praying for extension of 3 weeks time, my lord.
Extension of
2 weeks, my lord.
Lastly, the one suit is pending before the Civil Judge Junior Division of Alipur lawsuit. That suit was withdrawal lawsuit.
There was a direction to withdraw, my lord, for that part. My lord, I am filing the documents, my lord, as per direction.
Along with list of dates.
So suffering for the. Let some person sign. Who has prepared the list? So suffering for the petitioner.
Prepared by me for the prepared by me.
Now the objectors have come, na?
My lord.
Caveators have come.
Caveators are they are appearing.
So now it has to be treated as
contested.
So appearing for the petitioner. So appearing for the caveator. Caveator or caveatrix?
Caveatrix.
Caveatrix. Sole. One.
Sole.
Caveatrix. Full stop. Counsel for the caveatrix has handed over the copy of the order passed by the Learned Civil Judge Junior Division, 2nd Additional Court, Alipur, South 24 Pargana, dated 31st of January 2025, wherein the caveatrix has withdrawn the title suit number 669 of 2023. Let the same be kept with the record. Full stop. Counsel for the petitioner has filed the document, original document. Original document in the seal cover along with the list of documents. Let the same be kept with the record. Full stop. Full stop. Counsel for the petitioner prays for time as the petitioner is out of station, and counsel for the petitioner submit that the petitioner could not take appropriate stuff for amendment. Counsel for the petitioner submit that the petitioner could not take appropriate stuff for amendment in the probate application, and as such he prays for time. In view of the submission made by the counsel for the petitioner, the case is adjourned for 2 weeks. Please the matter on 6th of March 2020.
Lordship, 6th, not possible.
6th not.
6th and 7th, not possible.
11th of March.
As you know.
Next.
I'm grateful.
No, this is my application for letter of administration.
Yes.
He is only survived. He's only survived by his daughter and son. The son
Who
is
is the deceased? Somnath Ghosh.
yes.
When he
also
died?
he was also in defense. He died in 1998.
Somnath Ghosh. Where is the death certificate?
And
where is the death certificate of the Somnath Ghosh?
page 11, page 9 of the petition.
SN Ghosh. Dated 98.
Yes.
Yeah, then
His
how
wife.
many legal heirs?
It's only 2.
Where is that?
Uh,
Indrajit Ghosh and
Indrajit
Antara
Ghosh
Who is,
and his daughter.
who is the petitioner hearing?
Antara Ghosh, daughter.
Antara Ghosh, daughter of so and so. Yes. What about the Indrajit Ghosh?
Lord, Indrajit Ghosh is with defense, so most of the time he's always outside. So that is why he gave his consent to his sister.
Where is the consent?
Consent is separate consent is also attached.
Hey, consent है देखो. Affidavit consent by Colonel Indrajit Ghosh.
Colonel Indrajit Ghosh. Indrajit Ghosh.
Why? His father died 98. You filed the application in 2023.
Since he was also in defense, and the daughter sister was minor at that time, so they probably thought the mother will do it, but mother passed away in 2017. Thereafter, they decided to file for letter.
After the death of the mother.
Yes.
Where is the mother death certificate?
Mother 11, page 11 of the petition.
2017.
Yeah.
Since suffering for the petitioner. The petitioner has filed the present application for grant of letters of administration of the estate of the deceased Somnath Ghosh. Counsel for the petitioner submitted. The deceased died on 27/12/1998, leaving behind his wife Arundhati Ghosh, the petitioner, his son Indrajit Ghosh, and the petitioner being the daughter. Counsel for the petitioner submitted. The wife of the deceased died on 9th of February 2017, leaving behind the son Indrajit Ghosh and daughter Antara Ghosh. Now the petitioner has filed the daughter, namely Antara Ghosh, has filed the petition for grant of letters of administration. The son Indrajit Ghosh has affirmed his affidavit, stating that he has no objection for issuance of letters of administration to the petitioner with respect of the estate of the deceased. At the learned counsel for the petitioner peruse the application, death certificate of the deceased Somnath Ghosh, death certificate of his wife Arundhati Ghosh, affidavit of consent of son Indrajit Ghosh. This court find that the son has given his no objection for grant of letters of administration to the petitioner. Accordingly, this court find that the petitioner is entitled to get the letters of administration to the estate of the deceased. What is the cost? Affidavit of asset, what is the total value?
2 asset, 1 bank account and 1 whole property. Joint.
45 lakhs.
Yes, joint property.
The police, the department in the क्या बोला last में? You get it. The department is directed to issue letters of administration of the property and credits of the deceased to the petitioner throughout the state of West Bengal upon furnishing bond of rupees 4 lakh with one surety.
My lord, can the bond be reduced?
10%, 45 lakhs. I have given it for, otherwise I could have given 4,50,000.
My lord, one more line.
Colonel, what is it?
Waiver of draw and complete.
Okay. The department is directed not to draw and complete the order.
Great.
PLA number 7 is disposed.
Great.
For probate and letters of administration, my lord.
Yes.
That petition is being filed by the youngest son.
Yes.
The deceased, my lord.
Ready matter?
Yes.
Ready matter?
Yes,
Where is the will?
the will is at page 12, my lord. Page 13, my lord.
Page 13. What is the name of the testator?
My lord, testator is
Testatrix.
Bhagwati Devi Karnani. Yes, my lord.
Bhagwati Devi Karnani. Yes. Where is the name of the executor?
Name of the executor, my lord, is
Sanjay Karnani. Where is that?
name of the executor, my lord,
Appointed Sanjay Karnani
is at
as well
page
executor.
5.
Yes. Then where is the attesting witnesses?
Not the attesting witnesses are at page.
Nitesh Karnani, Shivratan Karnani.
They are at page 17, my lord.
What is the date of the death?
Date of death is 16th.
Date of the will?
Date.
September 2022.
Yes.
When he died?
16th March 2023, my lord.
23. When the application is filed?
My lord, the application was filed in August of 2023.
August 23. August 23. How many legal years?
Not 5 legal years, man.
5?
Yes, ma'am.
Where is that? Banwar's
Paragraph.
husband. Rita, daughter.
Yes, ma'am.
Saroj,
Married
daughter.
Yes, ma'am.
Manoj Kumar Karnani, elder son. He has not given the consent.
My lord, the special citation was issued on him.
Special citation issued. No
No
caveat
caveat, my
certificate
lord.
is there.
No caveat, my lord.
No caveat certificate देखो. And Sanjay Kumar is the petitioner here.
Yes, my lord. He's the youngest son.
Where is the no objection of all the legal heirs?
All the affidavits of consent are there, my lord.
The affidavit of consent देखो. उसका दो. बनवर लाल करनानी. और रीता. फिर उसके बाद सरोज भोपाल. फिर उसके बाद अच्छा नो केवेट सर्टिफिकेट नहीं है. अटेस्टिंग विटनेस का है इसका. शिवरतन करनानी. No caveat. नीचे नहीं है. No caveat is not there.
No caveat should be there, my lord. Has been issued.
है ना? Only one witness is attesting with one witness has given affidavit.
Yes, ma'am.
Census appearing for the petitioner. Petitioner has filed the present application for grant of probate of the last will and testament dated 20 September 2022, executed by the testatrix Bhagwati Devi Karnani. Counsel for the petitioner submitted. The testatrix has appointed the petitioner, being her younger son, as sole executor of her last will and testament in presence of two attesting witnesses. We submit that the testatrix died on 16th March 2023, leaving behind 5 legal heirs, that is husband, 2 daughters and 2 sons. Out of the 5 legal heirs, the petitioner is one of the legal heirs, and the husband and 2 daughters have given their consent. One of the elder son, namely Manoj Kumar Karnani, has neither come forward for giving consent or by filing affidavit in support of caveat. Accordingly, citations were issued, but in spite of the citation, the elder son has not come forward. Full stop. Not come forward, comma. The department has submitted no caveat certificate dated 6th November 2024, stating that no caveat has been lodged against the grant of probate of the last will and testament. Counsel for the petition submitted the out of 2 attesting witnesses, 1 attesting witness has filed his affidavit stating the fact that the testatrix has executed the last will and testament in his presence and in presence of another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executor of her last will and testament. At the learned counsel for the petitioner peruse the original will, death certificate of the testatrix, affidavit of consent of the husband and 2 daughters, full stop. The no caveat certificate of the department, no caveat certificate submitted by the department, and the affidavit of the attesting witness. This court find that the 3 legal heirs have filed their affidavit stating that they have no objection for grant of probate. The attesting witness in his affidavit has categorically stated that the testatrix has executed a last will and testament in his presence and in presence of another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executor. At the learned counsel for the petitioner, considering the above, this court find that the petitioner has proved the will and entitled to get the probate. Department is directed to issue probate to the petitioner of the last will and testament dated 20 September 2022 after compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA 306 of 2023 is disposed of. Next.
I'm obliged.
35. This is that matter where I've filed an application for discharge of the caveat. We tried to talk to the other side and everything else, but I think it was
it's failed, my lord.
Worthless.
Yes, my lord. My lord.
She was absolutely not interested. She said that we have proposed, so what we have to say. That is not the target. Whatever it is, Lordship, I am ready to proceed.
My lord, if
sorry, let me finish my petition.
go ahead, please.
So
Yes, what do you want?
My lord, I still have not been served with a copy of the probate petition, my lord.
Who are
My
you?
lord, it is necessary, my lord.
Who are you?
My lord, I am the daughter of the deceased, my lord. One of the daughters of the
Have you
deceased.
filed a caveat?
Yes, my lord.
Notice served.
My lord, notice, my lord, in my lord, submission, my lord, is to be served by the registrar, my lord, which has not been done. My lord, I have no information. My lord, the registrar, my lord, is supposed to serve a copy of the petition to me. My lord, that has not been received by me.
When you from where you received?
My lord, the information of this, my lord, I have received from, my lord, some other proceeding, my lord.
No, information. No, I am telling with regard to the notice of the present proceeding.
Yes,
have you received or not?
My lord, no, my lord. I have only received the GA, my lord, in this, my lord. My lord.
The GA, then receive the GA that's been served. So you've received notice.
My lord, notice of, my lord, the application I have received, my lord, not the probate petition, my lord. And my lord, the probate petition.
What is the GA, sir?
My lord, the GA is for the discharge of the caveat, my lord.
Lordship, may I come to the provisions? Thereafter, whatever Lordship says, I'll cross the all abide by. Lordship, here it says 24 under the testamentary rules. Lordship, we have been practicing in the original site since the beginning, so I don't have any option but to present the book. I know it's nowadays Lordship's interpretations are quite different. Caveat 24. Lordship, testamentary 35. Chapter 35, Rule 24. Lordship.
Rule 24.
Rule 24.
Yes. Caveat.
Any person intending to oppose the issuing of a grant of probate or letters of administration must either personally or by his advocate acting on the original side file a caveat in the registry in Form 12. Notice of filing of the caveat shall be given by the registrar to the petitioner or his advocate acting on the original side. Form 13. Now, 25, Lordship. Affidavit in support of caveat.
Any person intending to oppose the issuing the grant of probate or letters of admission must either personally or his advocate acting on original side file a caveat in the registry in Form 12. Notice of filing the caveat shall be given to the registrar of the petition. Yes.
To me. I am the petitioner.
Correct.
Now, there's a distinction as far as filing of a caveat is concerned. In my humble submission, there's nothing. There's no distinction. But what is the distinction? In 25 and 26, I would like to place both. 25 says affidavit in support of caveat. Where a caveat is entered after an application has been made for a grant of probate or letters with or without the will annexed, the affidavit or affidavits in support shall be filed within 8 days, shall be filed within 8 days, Lordship.
Correct.
Of the caveat being lodged, notwithstanding the long vacation, such affidavit shall state the right and interest of caveator on the grounds of objections to the application. Now, Lordship, this is a case where petition has been filed, caveat is lodged subsequent to that. Affidavit in support of caveat, in my humble submission, has to be filed within 8 days. The language is shall.
Correct.
And there is no option given. Now, Lordship, if comes to 26. Notice to caveator to file affidavit. Where an application for grant of probate or letters with or without will annexed is presented after a caveat has been filed, the registrar shall forthwith issue notice to the caveator. That is probably what my learned friend is submitting. But unfortunately, in this case, the petition had been filed, the caveat has been lodged thereafter, and it was duty bound. My learned friend's client was duty bound to file the affidavit in support of caveat within 8 days thereafter.
Correct.
Now, the rule does not provide any other exception, anything else. Now, that is the reason I come up with before your Lordship, which says 27.
Yes.
Consequence of not filing affidavit. Where the caveator fails to file any affidavit in support of his caveat in compliance with Rule 25, which is my case, or in compliance with the notice issued under 26, doesn't apply to me, the caveat may be discharged by an order to be obtained on summons. I have filed that application, which is my GA1. That let the caveat be discharged for non-filing of affidavit in support of caveat and let the probate be issued.
Yes.
Now, rest, Lordship, if it was the case of 26, of course, if the registrar had not served the notice, etc., we could have considered, would have been my way of looking at things. But 25 categorically says that it shall be filed, notwithstanding anything else. And the notice which was required to be given by the registrar was actually to me. That caveat has been served.
But this 24, any person intending to oppose or issuing the grant of probate letters of admission must be either personally or by advocate acting on the original side.
Yes,
so how the probate, how the caveat, unless the notice is not served?
Now, that is notice to be served to me.
No. You file the
petition
petition
for grant.
For grant.
And the caveat is filed thereafter.
No. If the petitioner, is he the legal heir?
Yes. He is one of the legal heirs upon intestacy.
He is a legal heir.
Yes.
Correct. He is a legal heir.
Out of 5, all have given consent except for the youngest daughter.
Correct. It's the legal heir.
Yes.
And the legal heir has not come by filing caveat.
Has come.
Just a minute.
Okay.
If the legal heirs have two options, either the legal heir has to file the consent,
yes,
or to file affidavit of consent. If both has not been done, if affidavit of consent is also not filed, caveat is not there, then the citation is to be issued.
If affidavit of consent is not given.
Not given.
Correct.
Then citation is to be issued.
Yes.
So here whether any citation, any affidavit of consent filed? No.
No.
If no consent is filed, then the citations has to be issued first.
But he has before issuing of the citation, which would have been the first order to be granted by Lordship, he has already filed a caveat. Now, wherever he might have got to know from, he has already filed a caveat under 24.
When you filed?
He has filed, the date is, he would be able to better say. I don't have a copy of the caveat because registrar never gave me notice, which is a big lacuna on the part of the department, I would think. But as would appear from my, I've obtained a certificate.
No, this would be done in May 2024.
Huh?
May 2024.
May 24,
It
filed
says-
caveat. Filed caveat.
Has been filed, caveat with Bakalanama has been filed by Sanjukta Ghosh on 17th May 2024.
Have you issued
Lord, he has
notice?
a notice of caveat.
Have you issued notice?
He has not
My
given
lord,
me
that
any
is not
notice.
my lord. It is to be done by
Sir
the
has also
registrar.
not issued notice.
No, my lord, not to my information, my lord.
The registrar has not given me notice. I have
That's
got
why.
to know.
That's why.
I have got to know. 17th of May, the department has just stayed quiet. My application is pending for grant since I have filed this. Scrutiny has been completed on 18th April. I have
18th
filed
April
this
2024.
24. I have filed this on 16th December
This what?
23. Now from 16th October, October 2023, this has been pending. The department completes my scrutiny on 18th April 24. And thereafter, a month after that, a caveat is filed.
Correct.
And the department stays quiet. Now, only in September, when I say what is happening, my order is to be put up before Lordship for order. He said, no, sir, there is a caveat. So then I take out a certificate because the registrar has not given me any notice. I take out a certificate, I come before your Lordship. Now, Lordship, if there is no distinction between 25 and 26, where the language of 25 is clearly says shall, because these rules, Lordship, since the time that I have joined this profession, we have taken, because we are procedural lawyers, essentially, Lordship, I have an attorney firm, etc. And that's been essentially my practice. Now, we have relied on this as the procedural law and the Bible of it. Now, if it needs to be changed, Lordship, give the judgment.
My lord, if I may say one thing, my lord.
Once you file the caveat, why you not file the affidavit
My
in
lord,
support of
without
caveat?
notice of the, my lord, without the probate
Maybe if
petition, my
it
lord.
is not
sir.
without the notice, you file the caveat.
Yes, my lord.
You had the knowledge.
My lord, on the mere
Where is
knowledge
the
of
caveat?
this, my
Show
lord.
me the caveat.
My lord, I have a copy of the caveat,
Caveat
my lord.
has, Madhima.
I would also like to actually see what is going on in the department. Because they would not give me a copy of the caveat under any circumstances.
So you file the caveat on 17th May.
Yes, ma'am.
And the caveat disclose the PLA and all these things.
My lord. Yes, my
Yes,
lord. I'm not. Yes.
PLA and justice.
Yes, my lord.
So if you file the caveat, what is your duty? You have to issue the notice to please provide the copy of the application.
My lord.
Respective 8 days, he has to file the affidavit.
Or
Now,
you have
we
to
have
file the
knowledge of
affidavit.
the PLA.
My lord, if my lord, I may say one thing, my lord, even with knowledge of the PLA, my lord, without receiving the probate petition, my lord, from the registrar or my lord,
Correct.
as my lord.
But the 24, 26 does not, 25 does not say that the registrar after the receipt of the notice from the registrar. You have to, where the caveat is entered after an application is made for grant of probate, the letters of administration, or with or without the will, the affidavit or affidavit in support of shall be filed within it. So you have filed the caveat on 17 May. Within 8 days, you have to file the affidavit in support of the caveat.
My lord, that is, my lord, within my submission, my lord, only after I receive the probate petition. My lord, that is because, my lord, if my lord comes to, my lord, 28, my lord, rule 28.
Yes.
My lord, the probate petition, my lord, is to be considered as the plaint, my lord, in the testamentary suit. My lord, on the mere knowledge of the PLA, my lord, it is not possible for me to file an affidavit in support of caveat. In which case, my lord, the affidavit in support is to be, support of caveat is supposed to be considered the written statement.
Correct.
My lord, on the mere knowledge of the PLA, my lord, where I have asked for notice, my lord, without due notice, my lord, let nothing be done, my lord. That is the
Where
only,
is the ask for notice? Where is?
my lord, that is on the basis of the caveat, my lord.
Where?
The caveat.
You have filed the caveat.
Yes, my lord.
caveat, then you have to file the caveat affidavit in support of caveat, nothing else.
My lord, if
So you have to issue the notice. I filed the caveat. Please supply the copy of the probate application. You have not done so, and the registrar also kept silent over there.
Lord, that is, my lord, possibly where, my
So
lord,
you cannot take the benefit of the registrar.
my lord, the notice, my lord, of the probate petition, my lord, is to be received from the registrar. My lord, that is.
If suppose if you could not have filed the caveat, then the notice is naturally citation has to be issued. Once you entered,
the caveat and I had filed the petition thereafter under 26, I was bound.
and
to serve a
even though this GA1 is filed, you have not filed an application for extension.
My lord, now, my lord, there, my lord, becomes one redundancy, my lord. If, my lord, if my caveat is discharged, my lord, since there were no orders, my lord, passed before, my lord, the citation is still to be issued.
To whom?
To my lord, I being the heir, my lord.
You being there, you had the knowledge of the caveat.
My lord, only of the petition.
Notice
my
to
lord,
whom is to be issued if the person is not entered.
My lord, I'm sorry, my lord.
If the person has not entered,
yes, my lord.
Legal heirs are not entered.
Yes, my lord.
Then the notice has to be issued.
Yes,
That's why I put the first question to the learned counsel, whether the notice has been issued.
Yes, my lord.
So now he is taking the benefit. Why the notice is to be issued when you have lodged the caveat?
My lord, that would.
Notice of citation we issue all the time that to bring the person before lordship.
Yes, my lord.
That's why you're already there, and that too in the PLA number. It is not in the PLA number. Okay.
Yes, my lord.
Some can be yes.
This is the reason, lordship, the department refuses to give it to us.
You've given the number, and you are not appeared before the court. You not issued the notice.
Application that 8 days have gone by.
You could have been filed an application
filing
to
my
supply the document and to supply the plaint and the application and to extend the time for filing caveat. You have not done so since May 2024.
The grave
Now
matter, lordship. We have been given very substantive right. My client has come with some expectation before the High Court.
So what can be done?
My lord, if my lord, I may refer to one thing.
So, show which provision you're showing.
My lord, once. My lord, let me refer to my lord, the Indian Succession Act, my lord.
Give the Indian
88, my
Succession
lord. Section 288 of the Indian Succession Act.
288,
my lord.
Yes.
My lord. My lord, I'm mistaken. My lord, 285, my lord. I apologize, my lord. My lord, this would perhaps be some.
Yes.
My lord, even in such a case, my lord, the notice, my lord, if there is a caveat, my lord, the notice, my lord, I'm not saying that I have, my lord, waived the duty to file, my lord, give notice to the petitioner. My lord, there is another issue, my lord, that arises out of this. My lord, even if I have knowledge or information about the PLA number, my lord, the petitioner would have to be served, my lord, in person then. My lord, whereas, my lord, the rules specifically say that it has to be served to the advocate of the petitioner. My lord, that cannot be done without notice of who the advocate for the petitioner is, my lord.
What?
Lord, if I have information, my lord, on the basis of some other proceeding.
What information you
my lord,
telling
of
that
the
you're not
PLA,
having the information?
my lord, of the PLA itself, my lord. I have.
PLA itself, you in the caveat, it's the
Yes, my
caveat
lord,
which
I
you
have
filed.
I have received the number which it has received, my lord. It has been filed under. My lord, the advocate for the petitioner, my lord, is not known to me. My lord, on that basis, my lord, I have filed a caveat to have some notice served to me, my lord, as in when some proceedings
Correct. If the notice,
are
see
continued.
here, the two lacunas are there.
Yes,
one, you have filed the caveat, you kept quiet.
Yes, my lord.
You have not taken any steps. Either you have not issued the notice to the counsel for the petitioner. Yes, I lodged the caveat. You know. Second lacuna, registrar has not issued the notice. Correct.
Yes.
Caveat is on record. And as per 25, 8 days your time is having.
Yes, my lord.
After filing the caveat.
My lord, in my submission, my lord, 8 days would begin, my lord, after I have received the notice from the registrar.
So you file the caveat and you slept in the house and the proceeding is going on, whether 8 days will continue.
My
lord, a copy of the rules. I have a look. Okay.
And he has filed this application. When this application was filed? December 2024.
Yes, my lord.
Discharge of caveat.
Yes, ma'am.
Have you filed an application? Have you filed an application for extension of time for supply of the copy?
My lord, that would only, my lord, I would only.
Now we are on February, sir.
Yes, my lord.
You had appeared in each and every date.
Yes,
this copy is served and you're contesting this application. Have you filed any application against this? You're also not filing affidavit in opposition of this.
My lord, this was.
Correct.
Yes.
First thing. Second thing, you have not filed any application stating that extension of time, the notice has not been served. Let the notice be served.
My lord, my lord, since it has appeared, my lord, if my lord recalls, my lord, ever since this has appeared, my lord, the petitioners for my lord, the counsel for the petitioner, my lord, has been.
The client is only delayed.
The matter, my lord.
Your client wanted only to delay the matter.
My lord, that would be.
And you are supporting the client without keeping the law beside you.
My lord, the law, my lord, is.
Yes. Once you have received the GA1, leave aside all the law. What the prudent lawyer will do once the GA1 is received?
My lord, seek affidavits in opposition. My lord.
Not seek affidavit. It is against you. What you will do?
Would seek to extend the time, my lord.
Then there is no application as of now. There is no application for extension of time. There is no application for issuance of the notice. So how the court can see?
My lord, the issue, my lord, is, my lord, still that I have been put in a very precarious position, my lord.
No.
My lord.
It's a ill advice. It can say ill advice.
Possibly, my lord. That has happened, my lord, before this, my lord.
For this, the client will suffer. Litigant will suffer.
My lord, if my lord allows me, my lord.
What?
My lord, if my lord allows, my lord, the probate petition, my lord, if I may be given a copy of the same, my lord. My lord.
How at this stage, how the court can say once you file the caveat and J1 is there, how the court can now say that you serve the copy without again and again I'm telling you not taken any steps.
My lord, the issue, my lord, is, my lord, that the matter was there was an attempt
I am passing an order, let it settle by the division bench.
My lord.
That will be better.
My lord, that would perhaps not.
Your client has to suffer something.
My lord, she has already suffered, my lord.
What suffer?
My lord.
Yes, she is enjoying. Suffering is the petitioner.
My lord, between 2023, my lord, and 2024, my lord, no steps were taken by the petitioner as well, my lord.
You have not filed an application for dismissal, you have not taken any application. You have not filed any application for dismissal of the probate application, filing the application, they slept over the matter.
My lord, the issue, my lord, remains, my lord, that without a copy of the probate petition,
Repeat case where the discharge is required.
My lord, if my lord allows me, then
what?
1 week, my lord, to file, my lord, an application, my lord.
Court is not an advisory jurisdiction, sir. This court is not holding the advisory jurisdiction to the clients.
My lord, I understand, my lord.
So-and-so appearing for the petitioner. So-and-so appearing for the caveat. The petitioner has filed an application being GA1 of 2024, praying for discharge of the caveat. Counsel for the petitioner submitted the caveat tricks of caveat
Caveatrix, my lord.
Caveatrix has filed the caveat on 17th of May 2024. Neither the notice of caveat was issued to the petitioner, by the learned advocate appearing for the caveatrix, or by the learned registrar of original side of this court. Full stop. Counsel for the petitioner submitted the caveat has been lodged on 17th of May 2024. He submits that as per Rule 25 of Chapter 35 of original side rule of this court, the caveatrix has to file the affidavit in support of caveat within 8 days. But that has not been done. Full stop. Counsel for the petitioner relied upon Rule 26 of Chapter 35 and submit that in the said rule also a notice is to be issued. In the said rule also, the 8 days has been provided for service of notice. But in the present case, the caveatrix itself has filed the caveat on 17th of May 2024, but thereafter she has not taken any steps to file affidavit in support of caveat. And as such, the caveat filed by the caveatrix is required to be discharged. Per contra, learned advocate appearing for the caveatrix submits that no notice has been served upon the caveatrix, and as such the caveatrix is not in a position to file affidavit in support of caveat. Full stop. Counsel for the caveatrix submits that if the notice would have been served upon the caveatrix, the caveatrix can file the affidavit in support of caveat, but the said occasion does not arise. Counsel for the caveatrix relied upon Section 285 of the Indian Succession Act 1925 and submits that until notice to the person by whom the same has been entered is to be issued, but in the said case, no notice has been issued. At the learned counsel for the petitioner, this court finds that the petitioner has filed the PLA application on 16th of October 2023. Full stop. The caveatrix has filed her caveat on 17th of May 2024. The petitioner has not issued any notice, and the caveatrix has not issued any notice of caveat to the learned advocate of the petitioner. The registrar original side has received the caveat on 17th May 2025, but the registrar original side has also not issued any notice to the learned advocate on record of the petitioner with regard to lodging of caveat by the caveatrix. Full stop. When the petitioner came to know that the caveatrix has lodged the caveat on 17th of May 2024, but the petitioner has not, but the caveatrix has not filed affidavit in support of caveat. Accordingly, the petitioner has filed the present application for discharge of caveat. This court finds that there are two lacunas in the present proceeding. That is, the petitioner the caveatrix has filed the caveat on 17th of May 2024. But the petitioner has not issued notice to the learned advocate and either to the petitioner or the learned advocate on record of the petitioner, intimating that the caveat is lodged. The registrar original side has also not issued any notice to the petitioner with regard to filing of caveat by the caveatrix. Now the petitioner has taken the ground that, and now the caveatrix has taken the ground, taken the stand that the notice of PLA has not been served, and as such it is not possible for the caveatrix to file affidavit in support of caveat. Full stop. Considering the above, this court finds that due to the fault of the learned advocate, the litigant should not suffer. Full stop. Rightly or wrongly, the caveatrix has filed the caveat on 17th of May 2024. It was the duty of the registrar to inform the same to the petitioner, but the same has not been informed. Thus, this court find that one opportunity should be given to the petitioner to file affidavit to take appropriate steps. Accordingly, the case is adjourned for a week. Let the matter appear on 4th of March 2020. Come on that day.
I think, Lordship, now that the order is made, I just wanted to say, I think, Lordship, that view was quite this thing. Actually, our division bench settling this kind of an issue probably takes away a lot of problems for people like me in advising and everything else. Anyway, Lordship has been always very fair and very kind.
No, see.
Previous occasion, I've come for a receiver matter and.
But the problem is that she is the, admittedly, she is the legal name.
Lordship, my only point, Lordship. Sorry, it's done. So it just allows me 2 minutes. Lordship, there were 5 heirs. Now the youngest daughter has an axe to grind with the brother, the only brother. Now the will has been made. The father has made the will. Mother has given. The 3 other elder sisters have given. Now, what is the reason? See, Lordship, there is one more reason. There is one more scope. If Lordship uses the discretion, if I may put it this way, having been in this procedural practice for so long, that prove the will in solemn form.
That's correct. But
Lordship discretion. Lordship, anyway, in an uncontested matter, can also ask for that.
That I am asking if this court find that it is not a fit
I
case.
get my witness.
Let they come. Let they come.
That's great for me.
36. Obliged, Lordship.
My lord, I am appearing on behalf of the applicant. The arguing counsel is out of discussion today, so kindly adjourn the matter for the today.
I am dismissing. Last occasion also, 17 January. Arguing counsel is not time to appear before this court. Only file. I am dismissing the matter. You file and your advocate will get the time to file and prepare an application for restoration. Correct. Not today. Tomorrow, nobody appear, I will dismiss.
37, I am for the petitioner. My application for letter of administration regarding the petitioners. Petitioner is the one son. 2 of son not give consent. So citation is required to issue citation.
Citation is required.
Yes, all and also
how many legal heirs?
3.
No one has come.
Yes,
how many persons are given consent?
No consent. Only one son is applied for letter of administration because the executor refused to act as the executor. So yes,
will is there.
Will is there.
So who are you?
I am for the son, one son. And the executor is the brother of the testator.
So he has not come forward.
Yes, also I am pay for the citation to the said executor also, said executor also,
Where is his name?
Name in will, kindly come to the will,
will, but where you have mentioned in the application?
Yes, I mentioned,
Where?
Page, in prayer also, paragraph, also, kindly see the page, 2, page 2, paragraph 2,
Page 2, paragraph 2.
Yes,
Yes.
That by the said last will, the disease Counsel appointed her brother, namely Vinod Bansal, son of such and such, as a executor of her last will and testament dated such and such. But the said refused to.
So appearing for the petitioner. The petitioner has filed the present application for grant of probate. The counsel for the petitioner submitted that the deceased alleged to have been executed a will by appointing one Vinod Bansal as sole executor of his last will and testament, but the executor has not come forward. Executor has not come forward for praying for grant of probate. Accordingly, the petitioner has filed the present application for grant of letters of administration. Counsel for the petitioner submitted the testator died and the deceased died, leaving behind 3 legal heirs, and none of the legal heirs have come forward for giving consent. Accordingly, the notice is to be issued. counsel for the petitioner further submitted the notice also to be issued to the executor of the alleged will dated 26th of and also prayed for issuance of notice upon the citation upon the alleged upon the Vinod Bansal being the alleged executor of the alleged last will dated 26th of April 2020.
And
Such as
also,
the submission made by the counsel for the petitioner
also one of the property in Delhi, my lord.
for use the counsel for the petition submitted one of the properties situated at
Delhi, my lord.
Which jurisdiction?
Jurisdiction, my lord.
Delhi. At Delhi, and as such, he also prayed for issuance of citation under section 283 within bracket 3 of the Indian Succession Act. Concerning the submission made by the counsel for the petitioner, prayer A, B,
and C also, my lord.
and C of the application is allowed.
I'm appearing for the plaintiff.
Yeah.
I'm for the defendant. My lord may recall, I'm only on one point was left. My lord, the claimant has made 2 claims for damages, 10 lakhs, 10 lakhs. I have cited 3 decisions that they have not proved their loss, nor have they proved the quantum. That part is over. And then next claim is on compound interest at 24%. There is no such agreement. So that takes care of 28 lakhs out of the 40 lakhs.
Correct.
Now, their main case is that they raised a bill, they did work for 24 lakhs and we have paid them 12.53 lakhs. Now, the receipt is for 12.53. They are claiming that receipt is a forged receipt because the words full and final settlement have been included. But other than that, as far as the money is concerned, they have paid that. There's no dispute on that. So that is where we are at present. So today, I had saw on the last occasion, I had taken time your lordship made a query to me to check which part of the bill which part of the measurement book was corrected unilaterally by us. Well, unfortunately, my copies are completely illegible. We were trying to find out the originals. We haven't done that, but it's not, I'll still complete my submissions on that. I won't be able to tell my lord which entries, because I also missed out what my learned friend argued, which entries they are saying has been deleted. And my lord, if I may take my lord to 2 or 3 documents that was left, page 163, first one of the brief of documents. This was the first, there were 2 supplementary bills. This is the first supplementary tender which was accepted by us. At page 163. The typographically, it's written second, but it's corrected by hand first. 163. My lord has that?
Yes.
Yes. On top, my lord will see second supplementary is corrected. First
supplementary.
So this supplementary tender
Yes.
to the original tender was for repair, etc., for 1,80,000 odd.
Yes.
This has been paid.
Yes.
So this payment was recommended and paid. There is no claim in respect of this.
Yes.
And obviously, this amount was not included in the final bill. I have no problem with this. Now, if my lord comes to page
163.
Yes.
The total amount is 1,73,000.
1,85,000.
The total.
Total, yes. Say.
Yes.
This is not this is exclusive of the 12 lakhs. This is not in dispute. I'm showing this for a reason, because the second supplementary tender, we are disputing that. Now that second one is at page. On page 163, we agreed to their rates. We do hereby agree to execute this rate and we've paid it. So that there's no dispute on that. Now, my lord will come to page 674. This is the second supplementary. Oh. So that is the I'm sorry, my lord, this is not the second. My 673, my lord, will see. 673. This is our letter once.
Yeah.
673.
673.
673 is this.
This is DD 34.
DD
34. With reference to the above, I submit herewith item-wise replies to your claim for first and second supplementary tender received in your letters above referred. Then, my lord, the first supplementary tender, well, I'm ignoring that because that has been paid. So there's no provisions, no staging, etc. Now, my lord will turn over the page. Second supplementary tender. The first item, there are 4 items. Supply, fitting and fixing of wooden board by polythene, balance quantity after first supplementary. Our reply was, this item has been provided for in the approved schedule of item 14 excess work, if done, will be made in excess statement. So we are acknowledging if they do it. Now, my reading, my lord, of all the documents is no final bill for these have been given, unless it is included. If it is included in that final bill, which is illegible, then we have paid it in full and final. Otherwise, there's no. Then, item 2, earthwork for removing 4 crossbuns. This item is included in the item earthwork with necessary lead and lift as provided in the approved work schedule. So this was already there in the original, not required.
So it cannot be said there's extra work.
Yes, so we never approved of this tender. Then extra lead for removing earth from crossbund. Reply is the same. Reply, it should be reply is the same as item 2. So all these, according to us, item 2, 3, and 4, they have all been taken care of in the work schedule. And as far as item 1 is concerned, we are saying that it is covered in the first supplementary, which we've paid now. But if there is excess work, we will pay. So this, my lord, was there the basis of their extra claim, this 12 lakhs. They're running 2 cases. One is, I did supplementary tender, you haven't paid me. I can understand this, then it will be limited to this supplying of wooden boards. It would be limited to that. The other claim which has come up after they accepted in full and final settlement, as per us, they said, no, we found out that one of your officers, my officers, who was, he wrote to them and gave them letters of copies that he was made to change the measurement book. From here, so the allegation against that employee was he had inflated it initially, he was made to correct it. Admittedly, when the correction was done, we did not give notice. So now my learned friend will have to show that because of these corrections, this is amounts to about 12 lakhs. This I could not find from anywhere. Now I'll show.
That is the case he has made out.
Yes,
that is the case we have made out. But then when it has to be proved which by which.
So my lord, what I could find, if it is there, I have really nothing to say. But the letter of this Barik gentleman is at page 681. 680, sorry, it begins at. So he was show-caused and this was his reply that he had surveyed the work and he had done the measurements at page 6, DD 37, your lordship.
Yes.
Yes. So if my lord turns over.
36, 37.
DD 30.
681.
Yes, 681. The numbering is a bit. Now that should be 680. If my lord turns over the page, there's a chart at the bottom. Original measurement and reduced measurement. So they have to come, I'm presuming, because this is what I could not fathom from the bill, was if these items were reduced from 31 to 21, 26 to 15, your lordship sees the cubic meters. Yes. So if my lord sees the reduced, I've done this, I will put it in a note, my lord, the reduced measurements, these are approximately what the contract allows. Approximately it comes to, this is 20,000 cubic meters, this has come to 21,000, etc. But this amount, they are saying they corrected. The measurement book we have produced, but I couldn't find these corrections in the measurement book. So I don't know if they proved it, which measurements were changed, etc.
But your officer has admitted this document.
Yes, yes, this gentleman was not called to give evidence. This is what was changed. Now, was that change correct or not? So I'm saying my first submission is this reduced measurement that my lord is seeing, that yes. I will match up. I can show my lord confidently that these were the contracted amounts. In the schedule of quantities, this was the amount. Now, initially, these amounts had been put in. Now, if these amounts, so what my last submission was that day, that the plaintiff is not clear whether his case is that these are the amounts that were in the supplementary tender. So if these amounts were already, now my lord will see the bill which was being paid, 610. I was exactly here and that's when we stopped because I said my copy is illegible and I had to come. 610, my lord. My lord has Form 27 running bill. I think we were having one page. exhibit
686.
61010. This is the only bill, the first and last RA bill. My lord has on top, there's a printed PW accounts form 27. Now about 4-5 lines from the top, your lordship will see serial number, it's 1 RA. So it's the first, that's the thing, and the date is on the first line of that, 29/3/96.
Lordship, this document was tendered by the defendant. Lordship, this document perhaps has not been tendered in evidence as exhibit. As
It is
per
not
my-
exhibited. I couldn't find it.
Lordship, it is not there in the record also. The original. It has not been exhibited.
Not exhibits here, evidence quickly. Because this is the bill that I'm relying on. Page 74, if my lord sees, we're just keeping 6110 my lord tagged. Page 74 is the covering letter. This is the covering letter for that bill. This, I think, is exhibited by them. This is to bring to your attention that the above noted work was completed on such and such. No payment has been received. We are submitting herewith the first final bill. You are requested to take. This is in 1996, 22nd September 95. So this first bill is the final bill. There's no dispute on there's only one bill. But if my learned friend says it's not been exhibited, then I'll have to go back to the board. The entire case is on this, my lord, as far as this is concerned. So if this is the final bill, my lord will see page 613.
Which bill you have exhibited?
Yes.
Lordship,
As
this
your
is
claim?
a document in custody of the defendant.
No, which bill you have exhibited?
Yes.
Lordship, I have exhibited the calculation which has, Lordship, if I indicate.
There is a lawyer's letter, which is the last document in this. That is our disclosure, where they have given the breakup of their claim.
So we are relying on that letter that was issued by Mr. Barik, where he had indicated that he has struck off in the measurement book, Lordship.
Correct. So which is
My-
the measurement, it's okay.
Lordship,
Now
and the
you have
document
to,
that I have exhibited is
so you have to prove, yes, 10,000 cubic meter work you have been done, but bill was paid 8,000, 2,000 is required, and that is corroborated with the evidence of the barring. If it is go example wise. So if where is your final bill?
Lordship, the final bill was with the defendant, that the original. Lordship, what I have, my case
You're
is
not
not
called
with,
for.
Lordship, my case is on the basis of the money receipt, where there was a tampering.
Correct.
The amount was crystallized. However, when the payment was made, that is where it was tampered and the figure was changed.
Correct, madam. Appreciate your argument. It is tempered and the amount is changed.
Yes.
But the quantum of the amount has to be come from the document. You have received.
Yes, Lordship.
There was deduction, whatever it is, correction.
Yes,
But
Lordship.
what is the document you have proved? Yeah, this is your final bill, and this final, because in the contract work,
Yes,
the bill is to be prepared as per the site,
Yes,
the MB book,
Yes, Lordship.
measurement book. Measurement book has to be maintained by the site in charge by signing the same
Yes.
in presence of the contractor.
Yes, Lordship.
And on the basis of which the bill is to be prepared and bill is to be submitted and you have to receive. Where is
This is exhibited. This bill is DD 33.
DD 33.
I'll show the question
What is the exhibit?
number.
What is the exhibit?
It's marked as the exhibit DD 33 in answer to question number.
Dekho, DD 33.
Exhibits the numbers here. Defendant's document.
No, exhibit
90. Can't be 90.
Exhibit. What is the exhibit?
443. DD 33 it's written.
No.
Document is tendered and marked exhibit DD 33. This is question 143. I'm sorry, 443. Question 443. Of the examination in chief. I don't know, it was continuously numbered. Can't be in chief.
DD put. नहीं आपका लिस्ट नहीं है क्या है लिस्ट There is no exhibit as DD 33.
জানি তো লিখেছে তো ওরকম।
You have only exhibited 4 documents and they have exhibited MMN.
Yeah,
Lordship,
the
if we
final
go by
bill.
the sequence,
No,
it
DD
would
देखो,
perhaps
DD
be
देखो,
exhibit 3.
DD.
Target
That to the third March.
Question number 431, exhibit 2
March
is
90.
related 3 also. DD
Probably.
33 legal.
Exhibit 2.
Then it would be exhibit 3.
No,
Should be
exhibit,
DD 3. Then exhibit 3 should have
It
been
should
marked.
be exhibit 3.
exhibit 3 is the memo. Is the memo dated 28 March 1996.
This was my difficulty.
Memo number 110 dated 28 March 1996.
Two 2007. This was.
গাউনি পাশই করিনি তখন completed my law study. না exhibit 2 আছে
3 হওয়া উচিত। Marked at 33.
Not exhibit.
It's the last portion of my chief. My lord, may I place the chief?
Yes.
Question 440 onwards, my lord.
No, exhibit 3.
Hmm.
Exhibit 3 is the letter of the subdivisional officer to the executive engineer, wherein it is stated that hence the first RA bill may be treated as a first and final bill.
Lordship, that letter has an enclosure.
28 March 1996.
Exhibit my
3.
lord, page 74. What was that?
Page 74 is just different.
Oh, that's the claimant has exhibited. This should be the
70.
same letter.
Page 73 is different.
আমাদের কত DD?
In this letter, it is mentioned. Kindly go through this.
Oh, handwritten letter.
That is the exhibit 3.
March 96.
Bill is obviously not here, though it's marked in the deposition.
It's a bill mark है देखो RA bill mark है
State have sent the first
RA bill.
So this is, it refers to the bill, but the bill is not here.
Not here.
But in then the deposition, if my lord comes to 440 of the defendant's witness,
440.
440 to Mr. A.L. Mukherjee, it's on 24th of August 2007 of Madhusudan Day.
Yes.
The question is whether the final bill amount was paid to him by the contractor. Up to the ad interim stage, payment was made when the assistant engineer in charge of the work had written a letter to the executive engineer that the entire work had done and no further. This is the letter my lord was just referred to. And no further work was required to be done and requested me to treat this RA bill as the final one. Accordingly, full payment of this bill in full and final settlement was made as per bill in full and final settlement. You have just referred to the letter. Is this the letter he showed him? Yes, this is the letter. Who has signed this letter? The letter is by Mr. Aduk. This is done. This letter was written in the usual course of business. Yes. Then he explains there's a 3-tier system.
Actually, this is not DD3, it is exhibit 3.
So yes, madam. So should be exhibit 3.
Exhibit 3.
But then this bill is then obviously not been. Because I think that was sought to be tendered, but the bill is DD 33. This letter is not DD 33. This confusion has been caused because of that. Then, my lord, he explains how the bill, then the document is tendered and marked DD 33, subject to objection. Something must have been lost because this document that was shown to him is not DD 33. DD 33 is at page 610, which is the bill itself.
What is the DD 33? 610.
I'm sorry, 607. Follow? No.
33, 659.
DD 33?
650.
Mm.
Bill is at DD 10.
Okay. So, but this is not the handwritten letter shown by my lord. আমি একটা বিলটা কোথায় বললাম 610 sorry 630 This is it. It's not been exhibited.
DD 33 is some other letter. DD 33. Now we are submitting here with the second supplementary tender for the supplementary item work and the excess quantity of item. Second supplementary tender in connection with the original work.
DD 33, which
Where is that letter that was exhibited? 26th of September.
it's a different document altogether.
Because if I'll
If you come to the page 661, whether this is exhibited, DD 33?
No, it's not in my lord's exhibits. That letter is there, which is referred to.
That an opportunity was given to inspect the documents. When I had inspected personally, when I found only certain documents dated 24th February, 28th March, which Lordship had just now.
No, they have only 6 documents, na?
Yes, but these documents are not there in the judge's brief.
You.
No, we have exhibited.
This DD 33.
DD3 is definitely defendant's document.
Maybe you can refer this. You're not referred that.
No, Lordship, because it's not exhibited, I have not relied on it.
This was exactly why I took time. Page 610 to 615, or rather 16. This was the bill that was paid. 12 lakhs 53 was paid against it. From 612 to 616. And your lordship will see all the figures have been corrected and signed by both the parties. On the basis of this, but now it appears you all has it that this is not an exhibit, and I was continuously saying that mine is completely illegible, so I can't rely on this also. But my basic argument, even if that document is not there, admittedly only one RA bill was given. Admitted.
No, but if you come to the DD 30, though it is not exhibited, come to the page 659.
Yes.
And come to the page 661.
Yes.
661.
661.
Yes. Kindly see 661 in the left hand side may be admissible some excess work.
If this document,
This
Lordship, the
130
plaintiff had already tendered as exhibit the same document, which is at page 68 to 71 of the judge's brief of documents, that has been exhibited as V.
That's why I'm asking. Exhibit V.
V,
Exhibit
Lordship,
V,
the
though?
same letter, because this is the plaintiff's letter.
Exhibit V, though?
68.
Page 68 to 71 of your PD 32.
Now, after this, did we give that letter which I showed? Page 68 from the letter is V.
I'm on the same document now. 29 dollars.
22nd 9
No,
September.
but page number will show. Exhibit V.
They're not matching with anything.
PD, that's PD 32.
Yes.
Now, this document, the document my lord just referred to, 660.
Yes.
That was the, it starts at 660. I'll just say, show my.
659.
659
to 661.
No, it starts at 659. This is their letter.
Correct.
To us. Now,
Correct.
these endorsements on the left side is after this letter, I showed my lord what our reply was. Only the claim one, we said, if it is in excess, we will give that polythene wooden boards. Because this letter is dated 29th August. The letter that I showed
25,
my lord
95.
was at page 673. This is 27th September, after this. That was the reply to this. Page 673 is the reply to this letter. So these claims that were made in the second, according
673.
Yes, 673.
This is exhibited.
That your lordship has got me now. I see the exhibits. I'll have to go through that one to see which is exhibited. I'm really sorry.
What you are doing?
No, we tried to see. Because I took time also, because mine is completely, they couldn't assist us at all, the state, this 1995 document. But I assume that it's exhibited, like this is their claim. If they haven't exhibited their supplementary tender nor the bill, but my learned friend has a nice copy, she can share that with us.
Twice, yes, I have given the time for inspection of both the
Perhaps
parties.
PD 36 is the same document, perhaps,
PD 36.
which is Exhibit Y.
Exhibit Y.
Perhaps the same document.
Inspection No, he's saying the person, he's pointing to the empty chair, he's saying your own nature.
I helped him with the copy also.
Yes, Exhibit Y.
Why? Not
That's
the same
supplementary.
Same
I'll
document.
check those. Because my learned friend has a complete list.
Yes,
It's been given, I'll see that.
No, I have given to both the parties to time, but I don't think the state has taken any.
No, but my learned friend has shared it. It was not given to me.
Because they were facing problems, I had supplied with my
But
copy
these are not disputed. None of, at least only that signature, full and final settlement is disputed. Now that, as far as the payment is concerned, also it's not disputed. Now my only submission, if I may just crystallize my last submission that I make, is in this bill, which apparently is not exhibited, the 610, if that already included these changes in the measurement book, if it was made as per the changes, well, that bill was about 12 lakhs something. A few thousand rupees has been deleted, it made into 1253 and they've been paid. It was never 24. That is my submission. So if it was 24, it must be based on a second supplementary, which they never raised an invoice for. And it was never approved by us. And we have said, if there is excess, we will consider as far as wooden planks are concerned. So my learned friend will have to prove their case, my lord, that was it because of these deductions that excess of 12 lakhs is showing in their claim, or was it because of the supplementary claim? Or is it the same thing? Because from the perusal of the document 610, they have signed and accepted it, the amount.
Where is the measurement book?
Yes, measurement book is there. Well, page 600. It
starts at
300. Yeah, it starts at 200 and
No, exhibit.
107.
Exhibit.
in
Exhibit.
DD5.
It is made exhibit.
Yes, it was produced. Yeah. DD4. DD4 205 onwards. So these corrections that were made, that is not measurement book, my lord, DD7, page 475. It's not now to see, we'll see it and come back. See the last date. And where's the date of this bill? 96, 96. If my lord comes to 606, and that letter is also there, my lord, at 608, I stand corrected. 606, the last page of the measurement book, it has been signed by the parties. It's 17th of July, 1995. And by the claimant, and we have signed last on 26/9/98 after this, 95, sorry, 95. Your Lordship, page 606, last bottom part. The subdivisional officer has signed again on 26/9/1995.
Where from you get?
Right at the bottom, the last page of the measurement book. Yeah.
606.
606.
But it's not matching here.
And 608 is the letter.
607.
Oh, I'm sorry, 607.
607, 26 September
Yes,
90.
95. And BBM has signed in 17 July. So after this, the bill was issued. There's the next document, 608 is the exhibit 3.
Yes.
So this has been exhibited. After this, the bill came. And the annexure to that letter, which continues in
Sorry. Yes.
which continues as a part of DD8, that seems to have not gone in as an exhibit.
Hence, the first RA bill may be treated as first and final.
Yes, that is there. This letter is
So this
proof.
is the first and final.
So the next
611 onwards.
Yes, Madam. 600, yes, 11 in your Lordship.
609.
10 in our thing. So this is that RA bill, which if the third page of that or fourth page of that bill, your Lordship will see both parties have signed in 1995 September. That's at page 613. 26 September 1995, we have signed.
26 September.
613, or maybe it's 614 in my Lord's book.
Yes, 614.
At the bottom, all these signatures have been done, and the amount comes to 12 lakhs. If the page before the signatures, my lord, 12 lakhs 4,851, right at the bottom, handwritten.
Next page. Where it is?
The second last page, my lord, may I show that?
Okay, 12 lakhs 4,000.
Yes. So after all these deletions, it started with 1260 something, it's become 12.4. It was never 24. This bill does not reflect that they had a claim for 24 lakhs. And then your Lordship will see the last page is completely illegible, but it's. That's if you don't have the original, then what will?
1254 was the carry forward. Then after that, 1253 happened.
No, 1204 was the carry forward on the next page. Then it comes up to about 1254, and we have paid 1253.
That was next page. Where BBM has signed.
It is not proved. The plaintiff has to prove that whether it was the difference is 24 of this 12 lakhs. So,
yes.
Or they should sit across the table and finish this. And the state has continued this matter from 1995. Five. No.
5 the dispute.
The dispute was 97. And if it comes down to of course, they have those other, like according to us, inflated claims for damages, 20 lakhs more and compound interest. But that I'm assuming compound interest they will not get even if they get the 12 lakhs. But my simple case is, as per this final bill, the amounts were coming in the region of 12 lakhs. We have paid 1253. They have accepted that. Now they say that no, the work we have done is 24 lakhs. It is the onus is on them to prove which is the work done. And if that deductions they can show, or if they had argued that this was the rate of work, the volume of work, showed us a calculation that they have done this work and we disallowed it.
Yes.
Then, because this bill that I am relying on which unfortunately appears not to have been added. This will contain the corrections made in the measurement book.
Yes.
And they have signed this and accepted this. That is why we wrote that it was written in the receipt, full and final settlement.
24 lakhs breakup they have given, that was never approved. No document is there that it has been approved.
In the lawyer's letter, they have tried to give a breakup of the 24 lakhs. But this, according to us, also in the reply to that, we have never approved of this second tender, second supplementary tender.
Second was the
Said that.
Yes. Next.
Well, as far as the unpaid bill is concerned, it's my case now that they have not proved that they have done work for 24 lakhs. The supplementary, first supplementary we paid, that is admittedly not included in their claim, 180. There's no claim about it. There's no demand also. And as far as the second supplementary is concerned, we approved the letter saying that we have only approved of item 1 if they could show it was in excess of the first supplementary. But there is no document for that. But in their demand, they gave a breakup not of the entire 24 lakhs. That is there. So, subject to what my learned friend shows, my lord, from the exhibits, I'm a bit handicapped on that. The letter of demand is a DD 42. We have also disclosed. I'm sure they have also. That bears from up to page 710. That's their breakup of the 24 lakhs. Now, my endeavor was last occasion that whether this relates to this bill. If it is relating to the bill, my defense is we have fully paid. If it is related to the supplementary tender, then my defense is we never approved of that. There is no question of paying that because you got that. So this 12 lakhs, they have not proved according to my submissions.
Yes.
If we get another opportunity to give a note and check the records, I'll do that. But the dispute is limited to this amount. Those are my
extra work.
If there is extra work, Lordship, may I come back tomorrow and argue because tomorrow there's a Lordship had scheduled it. Mr. Ghosh had said that he would continue, but
I don't think with this handicap I can't do. Here, how it? No, we saw the exhibits.
Lordship, I shall make my submissions.
Tomorrow.
Yes, Lordship.
This is the only thing now.
Lordship, there is two parts to this, my argument rather. The very primary evidence of the work executed is the measurement book.
Correct.
That was on record. And the engineer who was at site, who had taken or recorded the measurements, had admitted in a letter which was exhibited that I have cancelled a certain amount of work which was actually executed and recorded under pressure, and I had penned through those pages. I shall indicate the pages where
that's correct.
the primary document is there on record.
Correct. That is correct. But the problem is that what was the amount?
Lordship, that amount will appear from that. I shall indicate, Lordship, although there are supporting documents where the amount.
Because if this is the first, if it is the first and final bill, 12,53,000 admitted. There is no dispute at all.
Lordship, this document has not been exhibited. I shall also.
Not exhibited, but what the character document. You have made out the case that the pre-receipt which you have signed.
Yes, Lordship.
Correct. They have typed the 12,53,000 as a full and final settlement.
Yes, Lordship.
This is the case they have made out. Now you have made out a case. Now it is not a 12 lakh, it is a 24 lakh. And the amount, the excess amount, the excess work which you have executed, that was recorded in the measurement book. But subsequently, the officer has deleted that.
Yes,
and he
Lordship.
has accepted.
That is the balance amount which I'm entitled
And
to.
he has accepted during the in the reply. In the reply, he has admitted. Now the question that with regard to the deletion.
It is the deleted part of the work which has not been paid.
Correct. So what is the amount on that?
Lordship,
you can calculate that?
that is on the basis of the measurement books
So
as
if
well as.
it is related amount, that is the excess work or the tender work. Tender work cannot be because it's the final bill.
Also, it was supplementary too. There were two supplementary bills, and both of which has been paid.
Correct.
But the quantification was made.
That's why in the
I was indicated that
in the
this
second
is the amount
supplementary,
I'm
it is
entitled to receive.
in yes, in the second supplementary, they have mentioned if it is excess work, you will get the amount. So
First
you have
one
to,
is paid, not
first
both
one,
are not paid.
that's first supplementary.
Second one is not
Lordship,
finalized.
there was an admission with respect to payment of both. Thereafter, I have issued a money receipt with blank because the figure was to be, the digits were supposed to be put in. But it was never understood that it would be the full and final payment.
Okay.
Those words were also put in.
Okay. Come ready tomorrow?
Yes, Lordship.
Great. These are the three questions are
Yes.
there that you have to prove. Because they are taking the benefit of that. There is no supplementary bill.
There are.
Fix tomorrow also?
Yes, Lordship, at 2 p.m.
Concession suffering for the plaintiff. Concession suffering for the defendant. Full stop. The counsel for the defendant has argued. You concluded? Yes, counsel for the defendant has concluded his argument. Full stop. Counsel for the plaintiff submitted. She will argue the matter tomorrow. Accordingly, case adjourned. Let the matter appear and this is found that the matter is already fixed tomorrow at 2 p.m. It's at 2 p.m. Let the matter appear tomorrow at 2 p.m.
Item number 28 of the commercial list.
Yes.
Yes, my lord, my notes are ready, my lord. My lord, there were two applications. GA1 was my application for interim relief, and my lord, GA2 was my lord, the application filed by the defendants for rejection of plaint. My lord, may I? My lord, only two things, my lord. If lordship takes the notes that was filed by the plaintiff on the last occasion.
Written not defendant, plaintiff.
Yes, I'm sorry, my lord, defendants.
Defendant.
Yes, it's a combined note of both the applications GA1 and GA2.
Yes.
Yes, I was only, my lord, on page 5 of the note. If lordship sees, my lord, the defendants have relied on, my lord, 7th line from the top. There is a judgment referred to in the body of the note, Eldeco Housing and Industries Limited versus Ashok Vidyarthi and others. Reported at 2023 SCC Online, Calcutta 1612. But this judgment was not cited during the course of argument.
Yes. Have you got the judgment?
No, my lord, I am not carrying that judgment because this was not cited by the defendants. And, my lord, if lordship sees, my lord, the two documents which have now been disclosed along with the notes of argument, the first document is at page 12 and the second document is at page 15.
Yes.
Now, interestingly, my lord, nowhere there is any averment regarding these two, my lord, documents either in the application or in the affidavits that have been filed by the defendants.
Yes.
My lord, I would, though, my lord, I have dealt with these two documents in my note filed in GA1 of 2023. My lord, I leave it to your lordship whether your lordship will consider these two documents or not.
You dealt with?
Yes, I have dealt with. If lordship sees the note in GA1,
Yes.
page 6 onwards.
Yes.
Yes, my lord, Roman 4 paragraph B, capital B. It was the defendant's argument that the letter dated November 8, 2021 has been suppressed. And my lord, paragraph capital C at page 7. This was also a submission that the money receipt of September 22, 2021 is incomplete and was not issued by the defendants. I have dealt with it.
Yes.
Yes. Now, my lord, the last judgment that was cited by the defendants was a judgment of 2010-1 Supreme Court cases 689. My learned friend has relied only on one paragraph, that is paragraph 16, to show that for an order of injunction, I have to satisfy the three tests laid down in order 39 rules 1 and 2.
Yes.
Balance of convenience, prima facie case, and irreparable loss and prejudice.
Yes.
Well, this judgment, first of all, is distinguishable in the facts and circumstances of the present case.
Yes.
Well, this judgment did not arise out of a suit for specific performance. If lordship sees, well, if kindly sees, well, page 7, I'm sorry, paragraph 7, page 691 of the report, the issue that went up before the Supreme Court was post-decree. After the issues were framed and evidence was adduced, the suit itself was disposed of on transfer to the 4th Additional District Judge Tirupati, who dismissed the suit of the appellants and allowed the counterclaim of the respondent number 1 by granting a decree for permanent mandatory injunction, thereby directing the appellant number 2 to hand over the articles in his possession to the respondent number 1 within a period of 1 month from the date of delivery of the judgment in the suit. Now, at paragraph 8, feeling aggrieved by the judgment and decree of the trial court, the appellants filed 2 appeals before the High Court Judicature Andhra Pradesh, Hyderabad, which came to be registered at such and such. Now, my lord, in the pending appeals, applications for injunctions under Order 39 Rule 1 and 2, read with Section 151 of CPC seeking temporary injunction restraining the respondents from interfering in any manner with the functioning of the appellant number 2 as Mathadipati of the Mott was prayed for. Now, my lord, this prayer was refused by the Supreme Court. Lordship will find that at, my lord, paragraph 18 of the judgment, paragraph 18, page 693 of the report. My lord, because the appellant himself withdrew from the duties, hence, my lord, the Supreme Court did not interfere. My lord, the following circumstances also go to support the version of the respondent number 1. The second petitioner himself has addressed a letter dated such and such, which reads as follows. In view of the recent events, we have kindly decided not to involve in the matters concerning the authority of Sri Samasthan Adhyatkarta Vishwas as well as dharmic activities. Therefore, the pranamas again and again we pray request to relieve us as early as possible. This prima facie shows that the second petitioner has been still recognizing the first Mathadipati and therefore requested them to relieve himself from certain activities. A careful reading of the aforesaid findings observation made in para 22 of the judgment of the trial court would show that the letter dated 4th November 1999 clearly enumerates the fact that the appellant number 2 had wanted to be relieved from certain activities of the Mott and he had in fact sought permission from the respondent number 1 in this regard. Therefore, in our view, it was rightly held by the trial court in the final judgment that appellant 2 continued to consider the respondent number 1 as Mathadipati of the Mott even after the alleged proclamation of 1994. But this is the distinguishing factor. Because the person, my lord, who wanted an order of injunction to restrain someone else to act as the Mathadipati of the Mott, he himself addressed a letter saying that I do not wish to continue any further. Hence, my lord, the reliance in the proposition that the 3 tests have to be satisfied, my lord, does not borne out from the judgment, just a principle which has been discussed. And my lord, so far as my contention or my argument, my lord, I have indicated in my note, my suit is for specific performance of 2 registered development agreements. In a claim for specific performance, my lord, I had cited 2 division bench judgments showing, my lord, the very crucial fact that unless the immovable property, which is the subject matter of the present suit, if it is alienated, then even if lordship grants a decree for specific performance post conclusion of trial, my lord, the decree will be infructuous. It will be a paper decree. Hence, my lord, I am only humbly beseeching to pass an order to protect the subject matter of the immovable property. After that, my lord, the decree is, my lord, it depends on the trial and the merits and the demerits. But the interim protection is very necessary, or else if at all I succeed, my lord, I will have nothing to execute. Because if the property is alienated, my lord, the decree will be a paper decree and it will be infructuous. And these are my submissions, my lord. And my lord, one more thing, lastly, I would like to conclude. My lord, the judgment cited by my learned friend in support of his argument for rejection of plaint, so far as his contention that these are commercial disputes or these are not commercial disputes, the coordinate judgment in Merlin Projects Limited. My lord, in that matter, lordship will see, my lord, the learned judge, the coordinate bench has held that for the court to determine whether it's commercial or non-commercial, an in-depth analysis has to be carried out, that is at the stage of trial. Now, this was the observation or this was the ratio in this judgment, but that was the second paragraph of the judgment of the coordinate bench. Ultimately, the learned judge, my lord, in the last paragraph at paragraph 16 holds that the disputes involved in the suit are not commercial in nature. So once having decided that an in-depth analysis at the time of trial would be necessary for determination what is the scope of the agreements, the last observation was not necessary. That is the reason why the observation was set aside by the division bench. But these are my humble submissions.
My lord, I am appearing for the defendant in this matter. I have already filed my written notes. My lord, there are only 2 clarifications in respect of the Edelco. No, my lord, I'm just saying that Edelco judgment, which my learned friend indicated, my lord, it is only in furtherance of my argument. So it
That
was not
cited.
It was not cited, but I had indicated to my lord that there is a Supreme Court as well, because I was already relying on the fact that pleadings in excess of the plaint cannot be seen. And my lord, with regard to the last judgment that he has dealt with right now, my lord, in that judgment, the issue is that there was a term sheet executed, no agreement. In the present facts, there is an agreement. So it will be a non-commercial dispute.
Hearing in connection with GA1, na? GA1
yes,
and
GA1 and GA2.
GA1 and 2. Both.
GA1 and GA2 is concluded. Both the parties have filed their written notes of argument. Let the same be kept in the record. See again.
Much obliged, my lord.
I'm grateful. I have given copies of my notes to my learned.
My lords, please. May I please, my lords, my application, my lords, I appear on behalf of the executor. My lords, on the last occasion, your lordships had fixed today the matter for the proving of the will in solemn form, my lords, because we were relying on an authenticated copy of the registrar of assurance. My lords, in the meanwhile, we have been able to find the original. My lords, may I just hand over a copy of the original to you?
Bring the witness, exhibit. Where from you got this?
My lords, we have while we filed the probate, my lords, we had filed a general diary with the police, my lords. After lordships indicated, we made further searches and inquiries in the house, my lords, and the executor himself was able to find the will, my lords.
How it can be, sir? Within in your house?
My lords, we were not able to find it, my lords. It was a part. My lords, may I just indicate, my lords, the will is of the father, the executor is the son, the mother and the daughter are the witnesses, my lords. So therefore, my lords, the will was supposed to be within the family only. It was not supposed to go anywhere out. And my lords, no third party has also been named except for one Mitul Das, my lords, who's also a family member. So the will was supposed to be there, my lords. We were not, because my lords, we had advised that since there's an authenticated copy, therefore, my lords, they did not make further searches. But when it fell from your lordships that it has to be proved in solemn form, my lords, the executor is also here, but my lords, we made further inquiries and searches, and they were after we were able to lay our hands, my lords. My lords, may I just indicate the relevant pages, my lords?
Yes, your witness present.
My lords, witness is present.
Bring the witness.
Please.
বাংলা ইংরেজি
English.
আমি বলবো আপনি আমার সাথে বলবেন ঠিক আছে বলুন I solemnly affirm
I solemnly affirm
that whatever I depose
that whatever I depose
by way of evidence
by way of evidence,
I shall speak the truth
I shall speak the truth.
no part of it shall be false
No part of it shall be false,
and I shall not conceal anything
and I shall not conceal anything.
but I will
Arun Kumar Daga.
Kumar Daga
Malud,
Daga.
he's the executor, Malud. He's not the witness, Malud. He's the executor of the will.
spelling Daga
ARUN
The witnesses are the
KWOMAR
mother and
DAG.
father's name
Sri Kumar Daga. SHREE KUMAR.
SHREE Shri Kumar Daga your age
58.
8 occupation
Singer.
singer residential address
It's I live at both the places. Here at CF 382 Bungalow, CF 382 Salt Lake, 382 Salt Lake.
लिखे देने
And my Mumbai address is
they have to write it down
Yeah.
whatever you say they have to write it down
Okay.
kindly make sure yes sir
Mr. Daga, can you tell my lord that what is your relationship with the testator, Mr. Sri Kumar Daga?
I am a son.
Did he have any other legal heirs?
No.
Did Mr. Daga have any other legal heirs?
Yes, one sister and me.
Mr. Daga, are there any other legal heirs of Mr. Sri Kumar Daga,
No.
the testator?
No.
No, you made the right answer, right? Are there any other legal heirs of Mr. Sri Kumar Daga?
My sister and me.
Yes.
my sister and me
Can you indicate the name of your sister?
Sangeeta Sanghvi. Sanghvi. SANGEETA SANGHVI.
Mr. Daga, I'm showing you a document. Can you tell what is this document? Original, Miller's correct. Page 1. Internal page 1. What is this document, Mr. Daga?
Yes, this is the will of my papa, my father.
What is the date of this will, Mr. Daga?
It must be of 2014.
Kindly indicate the right date.
13th of May,
No.
2014.
No.
13th May 2014.
Mr. Daga, kindly come to page 6 of the affidavit of the will.
Yes.
Kindly indicate the date.
7th day of May 2014.
14.
Mr. Daga, can you indicate the witnesses who have signed,
Yeah, it was.
attested this will?
Yes.
Mr. Daga, can you identify the witnesses who have attested this will?
Yes. Savitri Devi Daga. My SAVITRI DEVI and Sangeeta Sanghvi. SANGEETA
Mr. Daga, kindly also indicate your relationship with these two persons.
Savitri Devi Daga is my mother, and Sangeeta Sanghvi is my sister.
Mr. Daga, can you identify the signature of the testator, Mr. Sri Kumar Daga?
Yes, it has been the thumb of my papa, my father, with my mummy signing on that.
My mother. Identified by my mother's signature. Mr. Daga, when did your father pass away?
In 2021, October 4, 2021.
Was this will registered by your father?
Yes, it was registered.
Mr. Daga, how did you find the original copy of this will?
Actually, this will was not. I was not getting this will.
Slowly.
I was not getting this will. So when I got that this will may be required, then I got this will.
You can say in Hindi also.
I got this will searching out thoroughly at my house.
Thoroughly.
It was rigorous, actually.
Search was rigorous.
Search was rigorous. So in some old bundles, I found this.
In
Some old paper bundles.
Original will.
Mr. Daga, when the will was lost, did you take any steps to recover the will?
Yes, I searched it a lot and asked so many people.
I searched it a lot
I searched it a lot and I asked so many people. But ultimately I couldn't find it.
Mr. Daga, I'm showing you a document. Kindly tell my lords, what is this document? Papa, ye tumhara complaint.
First, you have traced out the original will, and now you are lodging. It is confused. First,
So, Milord, that is why I indicated, but he did not. That's why, Milord, I'm showing it to him. Milord.
Yes, sir.
What is this document, Mr. Daga?
It was signed by. It was submitted by me at the police, Bidhanagar Police North.
For what purpose?
For not finding my will.
Is it what is it?
So it's an FIR.
Stop. At the time of filing of the probate case, have you filed the original will along with the application?
Yes, I had gotten.
Listen to the
Simple
question.
question I am putting. हिंदी में जानते हैं?
जी.
आप जब केस फाइल किया, उस समय आप ओरिजिनल विल फाइल किए थे?
नहीं, ओरिजिनल विल उस समय नहीं थी मेरे पास ना.
At that point of time, original will was not with me. फिर क्या किया आपने?
मैं ARS से उसकी ओरिजिनल उसकी कॉपी निकलाया बिल की. और वो
Thereafter, I obtained certified copy from the
yes, certified
registry
copy.
office. Yes. Then
I submitted this.
how you got this original will now? And before getting the at that point of time, there was no original will. What you have done? आपने क्या किया? ओरिजिनल बिल तो नहीं था.
हाँ.
आपने क्या किया?
मैंने खोजने की कोशिश की बहुत.
वो छोड़ दीजिए. फिर क्या किया?
फिर बाद में बिल मेरे को मिल गई तो मैं इसको जमा कर दिया.
You are coming with the evidence in the High Court. This is the way. Take the assistance from the senior, how the evidence is to be led. You are not taught to the witness, how the witness is to give answer. What is the document, how the document is to be described. So and so appearing for the petitioner. Counsel for the petitioner handed over the original copy of the will and submitted that initially the original will was not with the petitioner. Accordingly, the petitioner has filed this case along with the certified copy of the will. Finished. Subsequently, the petitioner has searched the said will thoroughly and the original will has and found the said original will in the bunch of document at the house, and now the petitioner placed the said original will before this court. Full stop. The petitioner is present and examination in chief has been started, but the counsel for the petitioner pressed for time to adduce the evidence on the next date. Accordingly, examination in chief of the plaintiff witness is deferred. The original will filed by the petitioner be kept with the record. Prepare the question, IR. Put the question. Come with the.
Milord, I was given the instruction that to move without the witness, Milord. So because of the Milord, it was there.
Has passed an order for solemn.
I understand, Milord. I
You
understand.
got this original will.
I understand. Deep.
List the matter on 12th March.
Deeply obliged.
My lord, I beg to appear online. My lord, at the very outset, I tender my unconditional apology.
Which one?
My
Which
lord,
one?
my lord, item 29. I tender my unconditional apology, my lord. I will not try to justify myself because I will rely on a contempt matter.
Mr. Bhattacharya, what has happened? Now you continue with that.
I tender.
This
No,
court
my lord,
cannot carry all the things which has been happened.
my lord, I tell your lordship. Your lordship.
And all the bar members knows what I am telling. That is up to.
No. My lord, the way your lordship tolerates us, and especially Mr. Chaudhary and me, especially Mr. Chaudhary and me in our Tom and Jerry fight, my lord, I have to give it to your lordship. Very few judges will actually tolerate my Tom and Jerry fight with Mr. Jishnu Chaudhary, with whom I have been a 5-year roommate. But I will take the entire blame.
This court is not tolerating. This court is enjoying the submissions of the
No, my lord, it is my fault. Exuberance of the juniors. My lord, I am the captain of the ship. I am sorry for that.
Okay, no
I
problem.
tender my unconditional apology.
Yes,
Well, just to recapitulate what I had pleaded, just 2 minutes. My lord, they have been running the case that it was the mark of Dr. Idris. But I had demonstrated to your lordship the name of their company was Dr. Ilyas's New Life.
Yes.
If they were aware of the fact that this was Dr. Idris's, they would have mentioned Dr. Idris's New Life, not Dr. Ilyas's New Life. Then I relied on Assam Roofing and all the judgments. I will not trouble your lordship with all that. Now I will straight away come to the judgments which they have relied upon. Now, first one is, my lord, the judgment of Sri Ram Education Trust, which is Manupatra, Delhi, which they had relied on. Lord Sri Ram.
मनु तो शायद दूसरा ये तो सब प्लेंटिफ का है, डिफेंडेंट ये झूठ का है.
It was a Manupatra citation which they had relied upon.
Manu DE 10181.
What is the name? What is the name of the party?
My lord, Sri Ram Education Trust versus SRF Foundation.
Yes. Sri Ram Education Fund. Yes.
My lord, kindly comes to paragraph 6, my lord. My lord, the third sentence, 5 lines from the top of that paragraph, my lord. There was a trademark registry had posed a question, and this is the response.
Yes, yes, sir. Yes.
My lord, your lordship has found this 5 lines from the top of paragraph 6.
Yes.
The plaintiffs in response thereto, by the letter dated 8/6/2012, had categorically taken a stand that the word Shriram was the name of a Hindu deity. I am not saying that New Life is the name of a deity or something. And no one could claim proprietorship to such a name. And further, that the word Shriram was common to trade. This was the plaintiff's stance, and that's why it was the injunction was refused. Now, paragraph 8, it is further contended that the defendant is entitled to use Shriram for its schools owing to common family lineage shared between the parties. The respective chairmen of the plaintiff and the defendant are real brothers, being sons of late Dr. Bharatram and grandsons of late Sir Sri Ram. The goodwill and reputation vested in the family name was first created by massive efforts of late Sri Ram, who established the premier as Sri Ram College of Commerce, Lady Sri Ram College, Sri Ram Institute. So this was the This was the reason why injunction was refused.
Yes.
Now, my lord, the second decision which they have relied on is a 2014 SCC Online Calcutta 19929.
Yes.
My lord, it's a 2-page judgment. My lord, kindly takes the second page.
Yes.
My lord, the last 4 paragraphs. My lord, it was first of all not an action for infringement. Today I have a registered mark. It is not an action for infringement. My lord, has your lordship found the 4th paragraph?
Yes.
It is not in dispute that Prashanta Datta is no longer trading through the instrumentality of private limited company. In absence of valid assignment, the right of Prashanta Datta vis-a-vis trademark cannot be denied altogether. The learned trial court has recorded that the memorandum of association supports the contention of the plaintiff. We have repeatedly requested Mr. Devnath to point out the memorandum of the company as to how it supports the contention of the plaintiff. He was unable to demonstrate. Here I have a registered trademark. He was my director. And today, he has the gall to stand up and say that, sorry, this mark does not belong to the company. Now, my lord, the next judgment is of Sri Dhananjay Rathi versus Sri Vasu Steels Private Limited. It is again the Manupatra decision.
Yes.
My lord, kindly There the trust was not made a party. Paragraph 12.1.
Yes.
The plaintiff deliberately and consciously did not make RRC or its trustees as the defendants when the present suit was originally filed, despite being aware that the plaintiff is not the exclusive. There, the plaintiff was not the exclusive owner. Here, the company is registered as the owner of the trademark. And RRC is also authorized to use the aforesaid trademark. Here, is he authorized to use the aforesaid trademark?
Yes. Next.
Now, my lord, the only another judgment I want to show on contempt, because what they have said in contempt, nothing more they have shown. My lord, contempt, if your lordship kindly takes the bill at page 572 of the contempt application, my lord. Because they, my lord, the rule in contempt is you cannot justify and seek apology. Justification and apology does not go hand in hand.
There is a contempt. Yes.
My lord, page 572, Mr.
Affidavit.
No, my lord, not the affidavit, the petition.
572.
Yes, Mr. Banerjee, Saptarshi Banerjee, if you can indicate which volume is it? 572 is in which volume? Kindly assist, my lord.
Volume 4, my lord.
Lord, this is the invoice.
Volume 4 starts from 545.
Yes.
572 is the bill. And your lordship looks at the date of the bill. It is 1st of September 2024, much after the order of injunction has been passed. And now, how do they justify this? Your lordship kindly looks at the justification. My lord, if your lordship kindly takes up the show cause of of Muhammad Zaki. Paragraph 9. My lord, last 3 lines from the bottom of that page.
Yes.
And I had shown to your lordship that they are saying NL Care, previously known as Dr. Ilyas's New Life. Well, last 3 lines, as far as bill at page 572 of volume 4 filed by the plaintiff is concerned, the bill does not pertain to the defendant against whom the plaintiff has obtained an ex parte, but pertains to one of the several shops owned by family members of the directors. I am the sole proprietor of the shop, which is not a party. I say that the defendant had given a written intimation to the said shop asking it not to sell its goods. I have explained the same to the staff member of the shop personally, asking them not to sell any medicines bearing the trademark New Life and NL till the operation of injunction. Then how did the staff have access to this bill? He should have concealed it. Now, apropos this, my lord, may I just show one judgment of the Supreme Court? Mr. Kundu, kindly hand over a judgment. 1954, SCC Online Supreme Court 33. My lord, paragraph 12. Though the facts were different, he is seeking apology and at the same time trying to justify himself. You know, that does not go hand in hand.
Yes.
Has your lordship got the judgment, my lord?
Yes, yes.
My lord, paragraph 12, the proposition is well settled and self-evident that there cannot be both justification and an apology The two things are incompatible. Again, an apology is not a weapon of defense to purge the guilty of their offense, nor is it intended to operate as a universal panacea, but it's intended. My lord?
From your reading, which paragraph?
My lord, paragraph 12. The first line is good enough.
Yes.
The proposition is well settled and self-evident that there cannot be both justification and an apology. He's trying to justify and seek an apology.
Yes.
My lord, these are my respectful submissions. I will just beseech your lordship, my lord, the interim order your lordship had granted on 19th of August, my lord, let it be continued, my lord. Let it be continued.
Filed an application, my lord, for extension. May I file an affidavit on this?
No, my lord, please, my lord, kindly. Mr. Rai Chaudhary, please.
So, concluded?
No, my lord. Your lordship recalls, my lord, Mr. Bachawat has said because there are certain new judgments which my learned friends cited. So if you're
this one, contempt.
No, not just this, my
That
lord, on the previous occasion also. So if your lordship kindly gives 15 minutes on another day, and then it can be concluded then. 15 minutes, my lord, on another day.
But I tell your lordship, my lord, your lordship has been such a pro-plaintiff judge, my lord. That's why the litigations, we are members of the bar, are thankful to your lordship. But actually, my lord, in Delhi, your lordship sees ex parte, your lordship sees the amount of ex parte orders they pass.
I don't know. What I feel, I am passing enough.
We are grateful to your lordship.
Where is your GA? GA ka naya wala?
Yes, my lord. There is a new GA. I will just indicate that, my lord.
GA, your lordship will kindly see paragraph 7 once, my lord. Only thing is your lordship had categorically refused to extend. That is why, my lord, paragraph 7.
No, your lordship had also said that you filed an application, my lord.
Categorically said, my lord. I don't recall your lordship saying.
Suffering for the plaintiff, suffering for the defendant. Full stop. Counsel for the defendant has concluded his argument in connection.
Plaintiff.
Counsel for the plaintiff has concluded his argument with respect of GA1 as well as the contempt application. Full stop. The plaintiff has filed an application being GA-Com 3 of 2025, praying for extension of
Interim order.
Extension
of interim order originally.
Who has adopted? You.
No. Originally on 19th August 2024, last extended on 24th January 2025.
Extension of the interim order dated 19 January August 2024, which was extended on
last extension on 24th January 2025, which expired on
January 2024, which was expired on 7th of February 2024. Full stop. Counsel for the plaintiff submit that on 7th of February, the matter was fixed as 3:45 p.m. as especially fixed matter as 3:45 p.m. But due to the bar resolution, the matter could not be taken up for hearing. Accordingly, the plaintiff could not made an application made prayer for extension of the interim order. Full stop. Subsequently, on Monday, the petitioner has made a submission before this court, but this court has not extended the interim order, and accordingly, the petitioner has filed the present application. Counsel for the defendant raised objection and submits that on 13th of January 2025, this court, on 10th of February 2024, this court has refused to extend the interim order, and as such, the interim order cannot be extended.
And also, my lord, now that the interim order is not there, my lord, balance of convenience is probably in.
Counsel for the defendant submits that the interim order granted earlier already elapsed on 7th of February 2025, and thus at present there is no interim order. Thus question of extension of the interim order does not arise. He further submit that if the plaintiff intend to extend the interim order, he has to extend the intent to pray for extension of the interim order, the plaintiff has to made out a fresh the case and balance the convenience. That's all.
Yes.
And that counsel for the respective parties peruse the application and produce the materials on record. This court find that this court has initially filed the interim order, ad interim order on 19 August 2024. Accordingly, the same was extended from time to time. On 7th February 2025, the matter was listed for action as a specific matter, but due to bar resolution, the matter could not be taken up for hearing. Thus, the interim order could not be extended. On 10th of February 2025, the plaintiff has prayed for extension of the interim order, but this court refused to extend without any application. Now, the plaintiff has filed the present application. Considering the above, this court finds that since the 19th August 2024, the plaintiff is enjoying the interim order, and now the case is at the stage of final hearing of the injunction application. Thus none of the parties, and thus it would not be proper at this stage. The interim order can be refused. In view of the above, the interim order granted earlier is reimposed till 28th of February 2025 or until further order, whichever is earlier. GH is disposed. List the matter when Mr. Machawat will be
Well, anytime next week, if your lordship kindly fixes for.
Let the matter appear on 25th of next
My
week.
lord, not 25th. 25th, I won't be there in town. I have a arbitration before justice.
Come on 28th then. On 28th.
Well, will your lordship kindly fix a time, my lord, for.
Time is कोई time खाली है कहीं?
Any day, my lord, for.
No, let it be 25th. Let it be 25th. Let it be 25th. I'll join virtually.
Now, Mr. Bachawat will available on 25th.
Yes, yes.
टाइम नहीं है. कौन सा डेट में टाइम है? 28 क्या टाइम है? अच्छा वो नहीं रहेगा. 28 Mr.
Yes, my lord.
28 at 11:30.
I'm grateful.
Grateful.
11:30.
Grateful, man.
But I am appearing in this matter for the petitioner. Manad, I was only beseeching your lordship. Manad, takes it up in the first week of March. Manad, we'll do the matter. Manad, I am a bit inconvenienced today. Manad, Mr. Lahiri will not object.
Last time also they took my. Yes.
No, I did, but
suffering an injunction, my lord.
Mr. Lahiri, I am personally inconvenienced. That is why I am submitting. Kindly, only in the first week of March, anytime, subject to my lord allowing that.
Hearing of injunction?
No.
Injunction and vacating.
No, it's an application for judgment upon admission.
But there an injunction has been passed by your lordship, so that is
injunction application.
No, judgment upon admission.
Judgment upon
with an order of injunction.
And what about the GA4?
GA4 is acceptance of
written statement. It is so both the application that pleadings completed.
Yes, my lord. But anytime first week of March, my lord, kindly, my lord.
So and so appearing for the plaintiff. So and so appearing for the defendant number 1.
Defendant number 2. Defendant number 1.
You are appearing 1.
I am for the plaintiff.
So and so appearing for the plaintiff. So and so appearing for the defendant number 1. Who are the other defendants?
But defendant number 2 is there. Mr. Joydeep Roy was appearing.
Counsel for the plaintiff. Press for fixing the matter in the first week of March 2025. Counsel for the defendant raised objection and submitted that the plaintiff is enjoying the interim order. Considering the submission, enjoying the interim order. Considering the submission made by the counsel for the parties for the interest of justice, the case is adjourned. Let the matter appear on 7th March.
Well, any time.
Time is the difficulty. I will fix the time then April.
No,
if you are ready on that.
7th March.
7th March.
So great.
Very grateful, man.
Next.
May please, my lord. I appear for the plaintiff. GA7 is before my lord. It's really for recalling an earlier order, or your lordship, it can be read in another way. It's an order 1 Rule 10 application. Very briefly, my lord, the facts of the case I'll tell my lord.
GA7.
GA7. Seeking for recall of the order of 21st November. Well, I'll very briefly tell your lordship the facts. On the defendant number 3, Nepal Shipping Multimodal Transport is a company based in Nepal. Is the pro forma defendant here. He has appointed the plaintiff. It has appointed the plaintiff as its agent in India. We are concerned with 583 containers that are going all over the country, my lord. Now, before I was appointed, before the plaintiff was appointed, defendant number 1, River Edge Shipping, was the agent. They terminated their agency and gave us the agency. Thereafter, my lord, we wrote to them and we filed the suit for recovering the containers that were under the aegis of the defendant number 1. At this point, my lord, GA4 was filed by my learned friend's client, who is now defendant number 2. Initially, he was not defendant number 2. Defendant number 2 was the pro forma defendant. An application was made that no, we have been appointed as agents by the Nepal company. And on that, so we opposed that on the first day and sought time to file affidavits. But Justice Mukherjee, my lord, he said that no, there's no need for you to file affidavits. I'm adding them as a party, and then you take steps accordingly. Because we wanted to rely on certain documents to show that this agreement which defendant number 2 claims to have with defendant 3.
Number 2 is the Regal container.
Regal.
And defendant number 1 is the River Edge.
River Edge is gone. And River Edge got terminated. He hasn't challenged his thing. And Prabhu Shipping has come in. Now, defendant number 2 is claiming. He is not claiming to be the exclusive agent along with me. But he is claiming that he has a claim against defendant number 3.
Who? Prabhu.
Regal has against Nepal. Now, against Nepal, if I call D3, Nepal. So really, he's not a necessary party. He can file a suit against that. But now when we opposed this application, we were told that no, I'm adding him as a party, you take steps. So then
adding the Nepal.
No, Nepal was there as a pro forma. D2 has come in. It should Regal has come in as defendant number 2. Now, our main contention, I'll come straight to the chase, Manoj, because the facts are, there are many facts I have to show, my lord.
Where is the order?
Manoj, the 132 is the order. But before that, my lord, just 2 pages, if I may show, my lord. One is page 92. 92. This is the agreement that Regal is said to have had with Nepal. Your lordship sees, this is the agreement, appointment of booking agent for India. My lord,
Nepal operating
8th of December 2020.
Yes.
Yes. Now, if my lord sees that at page 94, who has signed this agreement? On behalf of Nepal, your lordship will see one, Mohammed A.A. Sardar as managing director has signed. The company owns. So he has signed and someone else has signed for Regal. Now this Mr. Sardar, my lord, A.A. Sardar, he was a director of Riverside. He is also a director of Regal. I've annexed now all the documents we've got from the ROC, and he pretends to be the managing director of Nepal, my principal, and executes this agreement. Now, if my lord turns over the page, there's an addendum that is also signed by him. Mr.
So he's on both Nepal and
yes, he's claiming to be the managing director of Nepal. So on this basis, now if my lord comes to Justice Mukherjee's order at 132, I'm sorry. On this, though we took the point before my lord, and we wanted to come out with the documents to show the nexus between this Mr. Sardar and defendants number 1, the defendant number 2 as well, my lord. So this is the order. This is an application by Regal for addition of part.
Number?
Oh, I'm sorry, 132.
Yes. Yes.
So this is an application by Regal for addition of party. The applicant was appointed as booking agent for India, etc. Then, my lord, they relies on a letter, the last 2 lines of that page. The letter clearly undertakes they were placed under the direct supervision of the general agent of Nepal Shipping. Then, page 133, the bottom. This was our argument. On behalf of the plaintiff, the applicant's contention is seriously disputed. The plaintiff says that the agreements by virtue of the letter of 8th December and its addendum, which I showed, my lord, should be held as fraudulent documents. It has been signed on behalf of pro forma defendant by a person who, according to the plaintiff, is not the managing director of Nepal Shipping Lines. Although the applicant has not filed any action towards defending its right or asserting the same, but in view of the agreement arising out of 8th of December and 28th December, the applicant has been prima facie able to show there was an agreement between itself and the pro forma defendant. The plaintiff, on the other hand, cannot have any independent knowledge about the dealing of the pro forma defendant and the defendant, number one, and the applicant, except which they have derived from pro forma defendant. The entry of the plaintiff as a general agent is only after 1st April, etc. Then, in the circumstances, calling for affidavits as prayed for by the plaintiff will not change the scenario. If an affidavit is filed, the plaintiff cannot have independent knowledge according to the transactions between the defendant number one, pro forma defendant, and plaintiff. Well, after this order was passed, we did not prefer an appeal, but we made searches with the registrar of companies, etc. And now we can support, because his lordship's view was, you are only an agent of D3. The defendant 3 will come and say if it's a director or not. Now in this affidavit, we have got an affidavit from the defendant number 3 saying this Mr. Sardar was never a director. We have got the ROC and the list of shareholders, the master data also we have got, which shows Sardar was never a part of D3 as shareholder or director. And we have disclosed also the ROC master data records to show Sardar was a director of Riverside. Then he's now also of Regal, and he's making an agreement between himself, his own company, and he's pretending to be the director. So this application, in my respectful submission, Malad, the two options, since I didn't prefer an appeal, this can be can be treated as Order 1, Rule 8 to expunge him, because it's not a necessary party at all. Rule 10, sorry, correct. And secondly, or if my lord hears GA4 and treats this application as an affidavit opposition, of course, here the affidavits are complete. Your lordship will consider this application in detail to show whether he's a necessary party or not. In the meantime, I have got an injunction on defendant number 1 not to deal with these containers. We have also made an application GA3, which has not been moved, for the Calcutta port to give us these containers. Perhaps we will make an application also for receiver for all the containers that are there in India.
What is the condition of the container now?
The containers are being used according to us for other transportation. They're all in the transport business.
Correct.
So some of them have been coming back. Some of them have been there. 500. All the details of 583 are given in my GA1. It's there by page 200 and something. Yes. From 198
so
onwards.
Who is taking the benefit of this container now?
So
who is hiring the container?
Well, the allegations are they have painted over the numbers, but these containers have specific numbers which can be identified eventually.
That is seal number.
So those numbers we have given. So those containers are being used by this defendant number 1 by Mr. Sardar's companies as such. And our allegation is they have changed the outlook, the outside part, they've painted it, repainted it, etc. But because of this, 3 or 4 technicalities that were faced in this application, it could never be heard out. One was there were 2 notices of motion in GA1. That took 6 months for us to solve, because there was 2, we had to make an application, we had to delete one of the notice of motions, and then there was another.
We also had to serve.
Yes. Then after, my lord, after this order was passed, we made this application, but his lordship refused to hear the application unless we carry out the amendment. So we carried out the amendment. Now we want, your lordship will treat it as an amendment of plaint or Order 1, Rule 10 application, because
what is the prayer here?
But it is to recall this order,
of the order
and for deletion of his name. So
who is the prayer?
I am for the defendant number 2. My lord,
so now who is the defendant number 2 now? As per the amendment?
As per amendment, I am the regal container is the defendant number 2, my lord.
What is the name? Regal.
Regal.
So,
my lord, the appointment, the principal point by my learned friend is that I have not been appointed by the authorized person of Nepal shipping. The director's list has been annexed at page 152 of their application, where Mr. Devi Prakash Bhattachan is one of the founder director
of
of
the Nepal
shipping. My lord, kindly come to page 21 of my affidavit in reply. It is the letter dated 23rd September 20.
Who is appearing for Nepal?
Lord, I appear. I am the pro.
So what is your stand?
Lord, this Mr. Sardar was never my director. And it is my stand. In fact, there is an affidavit on behalf of my client already disclosed and annexed with this petition, which states these facts,
I'm coming.
disclosing Milord, the Nepal ROC records, which shows Milord, the directorial position. He was never a director.
My lord, kindly come to page 21
of your reply.
Of my reply.
Reply or affidavit? Opposition.
Sorry, opposition.
Lord, just one thing. Lord, I'm not standing in the way for hearing. This opposition has not been formally served on me because I was not the petitioner in GA7. But needless, he can continue.
Party.
He can continue.
I
I'll
will
get
serve-
a copy
then-
from him in the
then
meeting.
I will serve it.
I'll let it continue.
My lord has a matter fixed.
It's the problem.
Tomorrow, if it can be taken up first thing, my lord.
Not tomorrow. I have a fixed
Why
matter.
last time he was in
No,
difficulty?
not
my
tomorrow.
juniors have
I have a fixed matter before this Honorable Justice Boshak.
2 p.m.
So 2 p.m.
2 p.m. karo.
2 p.m. that other suit is there. Well, because they had come from Nepal and an advocate had come from Delhi, and we that time my learned friend was in trouble. I said
3:45. My lord, I will be able to come.
3:45
already
yes.
Day after tomorrow, my lord.
Justice Boshak অত ভয় পাচ্ছে
আরে contempt matter মারবে ধরে already মক্কেলকে টেনে নিয়ে যাচ্ছে
Well, if he's not there, we'll accommodate my learned friend.
Day after tomorrow.
Once on his ground, I took. That's why. But then
It's a commercial. Day after tomorrow, no commercial.
Oh. Next commercial.
No, I will have to serve.
No, I'm not standing in the way, my lord, because
no.
I'm not standing in the way of a date.
Let it just be not today, man. If he's in difficulty, we won't.
Suffering for the plaintiff. Suffering for the defendant number 1 and suffering for the defendant number 2. Counsel for the plaintiff has argued the matter, but due to possibility of time, hearing could not be completed. Leave the matter tomorrow. Come tomorrow. If see if it I'm in difficulty, I will accommodate. No problem.
Lord, your lordship has recorded defendant number 1. It's actually defendant number 2.
Defendant number 2 and defendant number 3.
Defendant.
Defendant number 2 and
No, you are the performer.
Yes, I am the
Defendant
performer.
3 is the performer.
Yeah. Counsel for the plaintiff has concluded his argument. Due to paucity of time, the defendant could not argue. Leave the matter. Next.
My lord, my witness is here. My lord, he was being cross-examined. The attesting witness.
Witness.
Yes, my lord. Attesting witness, cross-examined by Mr.
বাংলায় বল সুদীপ্ত মল্লিক
সুদীপ্ত মল্লিক স্পেলিংটা বলবেন কাইন্ডলি
SUDIPTAMALLICK
ছোট ছোট করে বলবেন আমি
Resume.
ঠিক আছে
মোবাইল থাকলে সুইচ অফ করে দিন ইয়েস স্যার
Cross resume, huh?
Phone, question 46 and 47.
দাদা এখানে নেই
46, 47.
46, 47. Yeah, इसमें.
Should I show mine?
46
and 47.
47 বুঝিয়ে দেবো
না না দেখি পড়তে পারবেন তো? পড়তে পারবেন? What is the monthly stipend paid to you by Isha Banerjee?
ঈশা ব্যানার্জি আপনাকে মাসিক স্টাইপেন্ড কত টাকা দিতেন?
স্টাইপেন্ড মিন্স মানে প্রশ্নটা বুঝতে পারলাম না, স্টাইপেন্ড মানে কি বলতে চাইছেন?
ঈশা ব্যানার্জি আপনাকে মাসিক
Stipend, monthly income. Question করে income. Monthly income paid to you by
ঈশা ব্যানার্জি দ্বারা আপনাকে মাসিক কত টাকা দেওয়া হতো?
দেখুন আমাদের মান্থলি ইনকামটা দুটোতে স্প্লিট থাকে, একটা
Our monthly income is splitted by two. One is
একটা যেটা আছে আমাদের স্যালারি হিসাবে আসে,
one is our salary, and
আর একটা যে পেশেন্ট আমরা দেখি অ্যাজ এ পে ক্লিনিক, সেই পেশেন্টের একটা পার্সেন্টেজ আসে।
the other part is percentage from which we treat the patients.
ঠিক গেল? দেখে নাও আনসারটা কি গেল?
One is our salary and other part is the percentage.
Percentage?
পে ক্লিনিকে যে পেশেন্টটা দেখি সেই পেশেন্টের
Other
পার্সেন্টেজ।
is the percentage of the patient treated.
I believe, my lord, subject to a percentage of the
patient
fees
fees.
collected from
Yeah.
the patient.
Could be that.
Yes, stated.
That is why I was. Now, what is your monthly salary?
আপনার মাসিক বেতন কত?
একটা জিনিস যেটা যে মাসিক যদি আমাদের 15,000 করে দেওয়া হতো,
We were given an amount of rupees 15,000 per month.
আর পে ক্লিনিকের ওটা অ্যামাউন্ট তো ভ্যারি করে, ওটা পেশেন্টের স্ট্রেংথের উপরে।
And the pay clinic amount varies with the patient strength. With the strength.
What is the last monthly salary that you have drawn? Or, no, sorry, what is the last monthly salary paid to you by Isha Banerjee?
ঈশা ব্যানার্জি কর্তৃক আপনাকে শেষ মাসিক বেতন কত টাকা দেওয়া হয়েছিল?
আমার একটা জিজ্ঞাসা আছে, মাসিক বেতন মানে যেটা আমি স্যালারি হিসাবে পাই সেটা, না টোটাল দুটো মিলিয়ে?
নিজেই তো বললো স্যালারি আর ওটা দুটো আলাদা জিনিস। Question repeated. কি বল?
The last monthly salary paid to you by Isha Banerjee.
ঈশা ব্যানার্জি কর্তৃক আপনাকে শেষ মাসিক বেতন কত টাকা দেওয়া হয়েছিল?
15,000.
15,000 rupees.
And what is the percentage that you get from patient's fees
আর পেশেন্টের ফিস থেকে
as incentive?
পেশেন্টের ফিস থেকে ইনসেনটিভ হিসাবে আপনি কত পার্সেন্ট পান?
পেশেন্ট ফিজ 350, ওখান থেকে 200 রুপিস পার পেশেন্ট।
The patient fee is 350 and from each patient I get an amount of rupees 200.
Now, when was the last increase in your salary?
আপনার স্যালারি শেষ কবে বাড়ানো হয়েছিল, বেড়েছিল কবে?
অনেক বছর ধরেই আছে, এক্সাক্ট আমার ডেটটা মনে নেই।
I do not remember the exact date, as the amount I am drawing, that is 15,000, is my salary for a long period of time.
By long period, how many years do you mean?
অনেক দিন বলতে আপনি কত
মানে
দিনের
এক্সাক্ট বলা সম্ভব না আমার
I
পক্ষে,
cannot
কারণ আমার মনে নেই আমার সেটা।
I cannot tell the exact date and time. I cannot tell the time.
Would it be 1 year, 2 years, 3 years, or more than that?
বছর, 2 বছর, 3 বছর, কত বছর?
অ্যাজাম্পশন আমি মানে করা যেত, কিন্তু বাট এক্স্যাক্টলি আমার কিছু মনে করতে পারছি না আমি।
I cannot remember that exactly. I cannot recall that exactly.
What about the percentage of patient's fees? When was the last increase in this percentage?
আচ্ছা, পেশেন্ট ফিস থেকে আপনি যে পরিমাণ টাকাটা পান, তাতে যে পার্সেন্টেজটা পান, তাতে শেষ কবে বাড়ানো হয়েছিল, বৃদ্ধি হয়েছিল, ইনক্রিজ হয়েছিল?
সেটা আমি এক্সাক্ট ডেট বলতে পারবো না, বাট অ্যাজাম্পশনলি ওই 7 to 8 মান্থ এরকম কিছু একটা হবে।
I cannot tell the exact date, but As far my memory goes, it was 7 or 8 months earlier that the increase was happened.
Do you know where Dr. Govindra Chandra Das presently is situate?
গোবিন্দচন্দ্র দাস কোথায় আছেন আপনি জানেন?
না এখন অ্যাট প্রেজেন্ট উনি কোথায় আছেন আমি বলতে পারবো না, কিন্তু ওনার বাড়ি হাওড়ায় সেটা জানি।
No, I cannot say where he is right now, but I know that his residential house is at Howrah.
Do you know whether Dr. Govindra Chandra Das will also be deposing in this matter before this honorable court?
আপনি কি জানেন যে গোবিন্দচন্দ্র দাসও কি এই মামলায় সাক্ষ্য দেবেন কিনা?
না সেটা আমি বলতে পারবো না।
I cannot say that.
I suggested to you that when you signed the codicil, Dr. Banerjee, Dr. Prashanta Banerjee was not present at that point of time.
উনি আপনাকে সাজেশন দিচ্ছেন, আপনি থেকেও পারেন নাও হতে পারেন। উনি বলছেন যখন আপনি কোডিসিলটাতে সই করেছিলেন ডক্টর প্রশান্ত ব্যানার্জি সেই মুহূর্তে সেখানে উপস্থিত ছিলেন না।
না উনি ছিলেন ওখানে।
I disagree, he was present there.
I suggested to you that the codicil was signed by you and by Dr. Govindra Chandra Das in the library on the ground floor of Dr. Banerjee's residence.
উনি আপনাকে সাজেশন দিচ্ছেন যে কোডিসিলটাতে আপনি এবং গোবিন্দচন্দ্র দাস সই করেছিলেন মিস্টার ব্যানার্জির লাইব্রেরিতে, যেটা কিনা গ্রাউন্ড ফ্লোরে।
না
Dr. Banerjee's residence.
না ওটা ফার্স্ট ফ্লোর কিচেন।
I disagree, it was at first floor kitchen. It was at the kitchen of the first floor. It was signed at the first floor.
I also suggested to you that you did not see Dr. Prashanta Banerjee allegedly signing the codicil.
উনি আপনাকে সাজেশন দিচ্ছেন যে আপনি ডক্টর প্রশান্ত ব্যানার্জিকে কোডিসিলটাতে সই করতে দেখেননি। আপনি মানেন না মানেন?
না আমি দেখেছি।
I disagree, I have seen him signing the codicil.
I suggested to you that the evidence which is being given by you is what Isha Banerjee has asked you to say.
উনি আপনাকে সাজেশন দিচ্ছেন যে আপনি এখানে যা সাক্ষ্য দিচ্ছেন তা ঈশা ব্যানার্জি আপনাকে যেভাবে বলে দিয়েছে বলতে সেভাবে বলছেন। আপনি কি একমত?
না না কোনোভাবেই না।
I disagree.
I suggested to you that the evidence given by you is designed to help Isha Banerjee.
উনি আপনাকে সাজেশন দিচ্ছেন যে আপনি যেভাবে সাক্ষ্য দিচ্ছেন তাতে করে ঈশা ব্যানার্জিকে সাহায্য করা হয়। আপনি কি সহমত?
না।
I disagree.
Isn't it true that Isha Banerjee has asked you to give evidence in this matter?
এটা কি সত্যি নয় যে ঈশা ব্যানার্জি আপনাকে এই মামলাটায় সাক্ষ্য দিতে বলেছেন?
এই প্রশ্নটা আমি একটু বুঝতে পারলাম না।
ঈশা ব্যানার্জির কথা মতো এখানে সাক্ষ্য দিচ্ছেন না দিচ্ছেন
না?
No, I disagree.
না আমি সেটা জিজ্ঞেস করিনি। That was not my translation.
কোশ্চেনটা বলার
Has asked.
ঈশা ব্যানার্জি
ওনাকেও সাক্ষী দিতে বলেছেন, নট কি সাক্ষ্য দিচ্ছে সেটা বলতে বলেছেন। দুটো প্রশ্ন আলাদা মানে হয়।
It is correct. It is correct. Isha Banerjee told you to give evidence.
No.
So who has asked you to give evidence in this matter?
আপনাকে কে সাক্ষ্য দিতে বলেছেন তাহলে এই মামলায়?
না অ্যাজ এ অ্যাটেস্টিং উইটনেস আমার যে সাক্ষ্য এসছে, আমাদের যে লয়ার বা যারা মামলা করছেন তারা আমাকে জানিয়েছেন, আমি সেভাবে সাক্ষ্য দিতে আসছি।
As an attesting witness, I was informed by the advocates that I have to give evidence, and as per that I am giving my evidence.
So it is your case that the lawyers have informed you about this proceeding and that is why you are coming to court to give evidence.
তাহলে কি আপনি বলতে চাইছেন যে লয়াররা আপনাকে ইনফর্ম করেছিল যে আপনার সাক্ষ্য আছে আর তাই আপনি এই সাক্ষ্য দিতে এসেছেন?
না আমি শুধু লয়ার বলিনি, লয়ার এবং যারা মামলা করছেন তাদেরও কথা বলেছি, তার মধ্যে নবনীতা ঘোষাল আছেন।
I have not only mentioned the lawyers, I have
mentioned the lawyers and the litigants. Among them, there is Nobonita Ghoshal.
এবং ঈশা ব্যানার্জিও আছেন, তারা জানিয়েছেন আমাকে।
Isha Banerjee is also there.
So you agree that Isha Banerjee has also asked you to give evidence in this matter and come to court?
তাহলে আপনি বলছেন যে ঈশা ব্যানার্জিও আপনাকে বলেছিল যে এই মামলায় এসে সাক্ষ্য দিতে, কোর্টে এসে সাক্ষ্য দিতে।
এখানে দেখুন সাক্ষ্য দেওয়ার পাবেন না, উনি আমাকে বলেছেন যে কোন ডেটে আসতে হবে অ্যাটেস্টিং উইটনেস, এবং সেটা যেখানে প্রশ্ন করাবে সেই প্রশ্নের উত্তর দেওয়ার জন্য।
Isha Banerjee told me the dates on which we have to come to the court and give my evidence. But পয়েন্টটা কি বললেন?
প্রশ্ন করা হবে, ওনাকে প্রশ্নের উত্তর দিতে হবে।
She told me that I will be asked some questions and I have to give answer to that.
I suggested to you that Isha Banerjee has also tutored you as to how questions are to be answered.
উনি আপনাকে সাজেশন দিচ্ছেন যে ঈশা ব্যানার্জি আপনাকে শিখিয়ে পড়িয়ে পাঠিয়েছেন যে কিভাবে প্রশ্নগুলোর উত্তর দিতে হবে।
না, না, একদমই না।
No, I totally disagree.
Isn't it true that on most occasions that you have come to court, you were accompanied by Mr. Ghoshal, Mr. Ashish Ghoshal, and you came in the same car?
এটা কি সত্যি নয় যে আপনি যতবার কোর্টে সাক্ষ্য দিতে এসেছেন, যতবার কোর্টে এসেছেন তার মধ্যে বেশিরভাগ বাড়ি আপনি আশিস ঘোষালের সঙ্গে এসেছেন ওনার গাড়িতে?
না।
নো।
Are you sure?
আপনি কি শিওর?
ওনার প্রশ্নটা যদি গাড়ি করে আসা হয় তাহলে আমি শিওর আমি আসিনি। ওনার সাথে হয়তো দেখা হতে পারে, কিন্তু গাড়ি করে আমি আসিনি।
If his question is regarding the accompanying him in his car, then I am sure.
ওনার সঙ্গে দেখা হতে পারে।
He has not come with the car, but he had a talk with him.
But I have talked.
I may have had a talk.
I may have had a talk with him.
But I have had talk. একটা question.
Has Isha Banerjee told you that Dr. Govindra Chandra Das will not be giving evidence in this matter?
ঈশা ব্যানার্জি কি আপনাকে বলেছেন যে ডক্টর গোবিন্দচন্দ্র দাস এই মামলায় সাক্ষ্য দেবেন না?
এই ব্যাপারে আমার কোনো নলেজ নেই, আমি জানি না কিছু।
I do not have any knowledge regarding this.
Is it not a fact that Dr. Govindra Chandra Das is nervous and will not give false evidence, and that is why he is not being brought?
Objecting to this question. How will he know whether the other person is nervous?
I withdraw. I withdraw that question. He has shown answer to question 99.
उसका मैटर तो नहीं हुआ। कब हुआ? फिर नहीं गया अगर उसका
मेरे छवि तो
कभी गया है ना।
प्रिंट कर रखो। Was it Nobonita Ghoshal and Ashish Ghoshal who have spread the word that the relationship between Dr. Prashanta Banerjee and Dr. Pradeep Banerjee was not good?
নবনীতা ঘোষাল এবং আশিস ঘোষাল
Spread the word in the chamber.
নবনীতা ঘোষাল এবং আশিস ঘোষাল কি সেই মানুষ যারা চেম্বারে এই খবরটা কি বলবো, খবরটা ছড়িয়েছিলেন যে ডক্টর প্রশান্ত ব্যানার্জি এবং ডক্টর প্রদীপ ব্যানার্জির সম্পর্কটা ভালো নয়।
না, এটা আমি কিছু বলতে পারবো না এই ব্যাপারে।
I cannot say that.
I cannot say anything in this regard. I cannot say that টা হচ্ছে না। I cannot say anything in this regard.
Yes, next.
Two more questions. I'm more or less done, my lord. Why did you not file any affidavit when the probate application was filed?
যখন প্রবেট অ্যাপ্লিকেশন ফাইল হচ্ছিল আপনি কোনো এফিডেভিট ফাইল করেননি কেন?
এটা আমি তো বলতে পারবো না, এটা আমার লয়াররা বলতে পারবে।
I cannot say that. My lawyers can say that better.
Do you know that Dr. Govindra Chandra Das has filed an affidavit in this court,
আপনি কি
in
জানেন
this matter?
যে এই মামলায় ডক্টর গোবিন্দচন্দ্র দাস একটা এফিডেভিট ফাইল করেছেন?
হ্যাঁ, আমি শুনেছি কিন্তু আমি কনফার্ম নয়।
Yes, I have heard that, but I am not confirmed.
Have you read that affidavit?
I'm not sure.
Oh, sorry.
আপনি কি ওই এফিডেভিটটা পড়েছেন?
না।
Answer no.
Shown question 9.
9.
দেখো তোমার ওখানে দেখো 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 I'm joking with you. You have said in answer to question 9 that when you went that between 3:30 to 4 p.m. on 11th May 2018, when you went to the first floor of Dr. Prashanto Banerjee's residence, an advocate was present. Who was that advocate?
আপনি বলেছেন যে 3:30-4টের দিকে যখন আপনি ডক্টর ব্যানার্জির রেসিডেন্সে যান, বাড়িতে যান, তখন আপনি গিয়ে দেখেছিলেন যে ওখানে একজন অ্যাডভোকেট অলরেডি আছেন। কে সেই অ্যাডভোকেট, নাম বলতে পারবেন?
মিস্টার রাজেশ উপাধ্যায়।
মিস্টার রাজেশ উপাধ্যায় was the advocate. Was that advocate?
You have said that this advocate took some signatures. Whose signatures were taken at that point of time?
আপনি বলেছেন যে এই অ্যাডভোকেট কিছু সই নিয়েছিলেন। কার সই নিয়েছিলেন?
ডক্টর প্রশান্ত ব্যানার্জি।
He took the signature of Dr. Prashanto Banerjee.
Your signature was not taken at that point of time?
আপনার সই কি সেই সময় নেওয়া হয়নি?
ডক্টর প্রশান্ত ব্যানার্জি সিগনেচার কমপ্লিট করার পরে আমাদের সিগনেচার নেওয়া হয়েছিল।
After the completion of the signatures of Dr. Prashanto Banerjee, our signatures were taken.
So at what time did this advocate take these signatures?
ঠিক কোন সময়ে এই অ্যাডভোকেট আপনাদের সইগুলো নিয়েছিলেন? এই সইগুলো নিয়েছিলেন।
মানে আমাদের সিগনেচার না স্যারের?
আপনাদের শুধু, তাই তো?
ওই স্যারের আপনাদের সবাই, ও তো একসঙ্গে বলেছে।
হ্যাঁ, অ্যারাউন্ড 6:30 মানে অ্যাপ্রক্স আমার মনে পড়ছে, এক্সাক্ট মনে পড়ছে না, সরি।
or 6:30 in the evening.
So what happened between 3:30 to 6:30 p.m.? You were just waiting.
3:30 থেকে 6:30 পর্যন্ত কি হয়েছিল? আপনারা কি অপেক্ষা করছিলেন বসে?
হ্যাঁ, আমরা অপেক্ষা করছিলাম এবং স্যারের সাথে কথাও বলছিলাম।
Yes, we were waiting and we were also chatting with sir, that
Dr.
is
Prashant Banerjee.
That is Dr. Prashant Banerjee.
Who else was present along with you, Dr. Prashant Banerjee, and the advocate you have just mentioned?
আপনি যে অ্যাডভোকেটের কথা আপনি বললেন এবং ডক্টর প্রশান্ত ব্যানার্জি ছাড়া সেখানে আর কে কে উপস্থিত ছিল?
ডক্টর গোবিন্দচন্দ্র দাস, আশিস ঘোষাল, ঈশা ব্যানার্জি।
Dr. Govindachandra Das, Ashish Ghoshal, and Isha Banerjee were also present there at that time.
So I take it, so is it your evidence that between 3:30 to 6 p.m. Dr. Prashant Banerjee, Ashish Ghoshal, Isha Banerjee, Dr. Govindra Chandra Das, and the advocate, Mr. Rajesh Upadhyay, were present and all were chatting?
তাহলে কি আপনি বলতে চাইছেন যে 3:30 থেকে 6টার মধ্যে ডক্টর প্রশান্ত ব্যানার্জি, আশিস ঘোষাল, ঈশা ব্যানার্জি, গোবিন্দচন্দ্র দাস এবং আপনি যে অ্যাডভোকেটের কথা বললেন তারা সকলে উপস্থিত ছিলেন এবং সবাই কথা বলছিলেন আর কি?
অ্যাডভোকেট স্যার যিনি ছিলেন একটু পরে জয়েন করেছিলেন, কিন্তু প্রথম থেকে আমরা 4 জন ছিলাম, কিন্তু সবাই একসাথে তো ছিলাম না, কেউ আসা যাওয়া করবে।
The advocate joined later, but he was not there from the beginning of the time. He joined later. We were not together. বলুন।
না না, একসাথেই ছিলাম, কিন্তু সবসময় একসাথে ছিলাম না, সেটাই বলছি।
We were not together all that period of time, that is 3:30 to 6 p.m. বলুন তারপর।
When exactly did the advocate join you?
Throughout that period, my lord, if that can.
Yes, 3:30 to 6:30.
When exactly did the advocate join you?
অ্যাডভোকেট কখন আপনাদের সঙ্গে সে জয়েন করলেন, যোগ দিলেন?
সিগনেচারে যে টাইমটা করানো হচ্ছে তার কিছুক্ষণ আগে এসেছিলেন উনি।
The advocate joined us before the time of the taking of signatures, of the signatures.
So did the advocate come before the registrar or after the registrar?
রেজিস্ট্রারের আগে এসেছিলেন না রেজিস্ট্রারের পরে এসেছিলেন অ্যাডভোকেট?
রেজিস্ট্রার আগে এসেছিলেন।
Before the registrar came.
Can you recall how much time was before how much time the advocate had come?
রেজিস্ট্রারের কতক্ষণ আগে এসেছিলেন বলতে পারবেন মনে করে?
সিগনেচার 6 to 6:30 অ্যাপ্রক্স এবং রেজিস্ট্রার তারপরে এসেছিলেন।
The signatures were done at around 6 or 6:30 in the evening.
6 to 6:30.
6 to 6:30 in the evening, and the registrar came after that.
I suggested to you that the evidence which has been given by you in this matter is not true and incorrect.
উনি আপনাকে সাজেশন দিচ্ছেন যে আপনি যা সাক্ষ্য দিচ্ছেন এই মামলায় তা সত্য নয়, ইনকারেক্ট, তাই তো? সত্য নয় এবং সঠিকও নয়। আপনি ওনার সাথে সহমত?
না, সহমত নয়।
I disagree.
I suggested to you that the evidence given by you is designed to help certain persons, including Isha Banerjee, Navonita Ghoshal, and Ashish Ghoshal.
উনি আপনাকে সাজেশন দিচ্ছেন আবার যে আপনার সাক্ষ্য এমন ভাবে তৈরি করা হয়েছে যাতে করে কিছু মানুষের সাহায্য হয়, যার মধ্যে আশিস ঘোষাল, ঈশা ব্যানার্জি, নবনীতা ঘোষাল আছেন। আপনি কি সহমত?
না, সহমত নয়।
I suggested to you that your evidence with regard to the physical and mental health of Dr. Prashant Banerjee, both on 11th May 2018 and 14th May 2018, are incorrect.
আপনি যে সাক্ষ্য দিয়েছেন ডক্টর প্রশান্ত ব্যানার্জির শারীরিক এবং মানসিক অবস্থার ওপর, যেটা যেমন কিনা 11ই মে 2018 এবং 14ই মে 2018-তে ছিল, ওনার শারীরিক এবং মানসিক অবস্থা যা ছিল তা সঠিক নয়।
আমি ওনার সাথে সহমত নই।
I disagree.
Well done.
That's all.
So you can step down and stay here.
Any further witness?
One more, at least.
So appearing for the plaintiff. So appearing for the defendant. Plaintiff witness is present. Cross-examination resume.
জানি না ওটা যদি দেখাবে
and
আমি জানি না।
concluded. Witness is discharged. Counsel for the plaintiff submitted. The plaintiff will adduce further evidence.
My lord, is there evidence closed?
No, further evidence.
Further,
Which date has been fixed, my lord? The lordship will fix the date.
kindly fixes it
Counsel
after
for
a
the plaintiff
fortnight.
submitted. The plaintiff will adduce further evidence. Accord full list. Let the matter appear on. Give the date.
Anytime, my lord, in March.
Hmm?
Anytime in March.
April. 8th April.
8th,
2 p.m.
2 p.m., my lord. Yes.
8th April 2 p.m. for witness action of the plaintiff. Witness number 2 of the witness action. Witness number 2 of the plaintiff. Examination of the plaintiff. Witness number 2. Examination of the plaintiff. Witness number 2.
My lord, will it be your lordship's pleasure to direct, my lord, a list of witnesses to be given?
How many witnesses you will? Yes.
But, let the other witness, this is only the second witness we've
Now,
got.
if you are giving the list,
Perhaps,
of
my lord, there may be one more after the next witness.
give the list.
I'll give the witness.
Give the list of.
I'll indicate it, my lord, on the next day. Yes.
हाँ तो यही नहीं ना आज है
Great.
नहीं है छोड़ दो। Yes.
Next item 33. If Malak, can you take it up on behalf of the respondents? 24th of February, Malak.
Which for the other side?
Malak, other side there was there, so I'll just inform him.
In which? 33?
Malak, 24th of February, if Malak desires, 24th of February, Malak.
24th of February. 33 record and order. So appearing for the plaintiff, so appearing for the defendant. As per the prayer made by the counsel for the defendant, let the matter appear on 24th February.
Deeply obliged.
One matter, I am praying for a leave, my lord.
For what?
My lord, this is a PLA matter.
Ah.
My lord, one advocate engaged this matter, then he filed a no objection. But the stamp paper in the name of the prior advocate. My lord, kindly.
Stamp paper, no objection. What stamp paper?
Stamp paper, which stamp paper?
Whose no objection is required?
Yes,
Whose
my
no
lord.
objection?
My lord. The court fees, my lord.
In whose name?
The
What no
prior
objection? Who has given no objection?
My lord, the Partha Chakraborty, the learned advocate, is engaged prior time, my lord.
On behalf of whom?
The
Petitioner.
executor, my lord.
Then
he no objected.
He has given the no objection
Yes,
to
my
you.
lord. To Mr. Bikash Kumar Roy, the learned advocate.
Okay.
But the stamp paper in the name of on
Erstwhile
first
advocate.
advocate, my lord. Will you kindly leave this
What leave?
for departmental
Leave
procedure.
is granted to file the no objection, which is in the name of the erstwhile advocate.
Good. Leave to accept this stamp paper. Kindly leave.
That's why leave is granted to accept the no objection submitted by the present advocate. In the leave is granted to accept the no objection given by the erstwhile advocate in his name in the bond. That is.
Yes, my lord. Thank you, my lord.
Yeah,
Sorry.
बताओ यहाँ तो. Thank you.
My lord, Probably, my lord, a leave has to be granted to accept the stamp paper, my lord.
Yes, my lord.
My lord.
No, it is not in the name of the erstwhile advocate.
Either advocate has. My lord, either this department has to, it has to be in the name of the executor or the advocate on record. Since there is being change in the advocate on record.
To accept the wakalat and the press wakalatnama. In the wakalatnama?
No, my lord, in the
stamp. Wakalatnama. Accept the wakalatnama which is in the name of the erstwhile advocate. Erstwhile advocate.
My lord, stamp paper, not a vocalatnama.
Not the wakalatnama which you
Stamp
So why you are not filed the wakalatnama?
already filed, my lord.
Department.
I fail to understand still.
My lord, department is be directed to my lord to accept the stamp paper. My lord, since the stamp paper is the name of an earlier advocate.
Why it is the stamp paper is the court fee?
Yes, my lord, court fees. Court fees stamp.
You are not stated.
Yes, my lord.
Yes, my lord.
Department is directed. Leave is granted. No, get it in. The department is directed to accept the court fee in the name of the erstwhile advocate Partha Chakravarti.
Yes,
Tell that.
sorry, my lord. Next time.